Adjournment request, if any, from item number 1 to 8.
Okay, so.
May I please, your Lordship, my lord? Lordship, I may be excused, my lord, in respect to item number 3. My lord, because of my illness, I could not prepare the case during vacation. My lord. I was, my lord, under treatment during that period. Just 1 week time may be granted, in the first week of August, I will do it without fail. Obliged.
May it please, your Lordship. Lordship, in item number 8, Lordship, I need to file an implement petition, Lordship. I could not find out all the names, Lordship. So I request some more time, Lordship.
Was 4/10/2023 order was there.
Lordship, recently, Lordship, the Honorable Court directed that I should implement the persons against whom I silenced the scene.
On 4/10/2023, court has observed this.
Lordship,
The petitioner are interested in pleading those persons.
Lordship, there are some grade 4 employees who got promoted, Lordship. Those I could not just locate, Lordship. Just 2 weeks time, Lordship. 2 weeks. Much already.
May please, your Lordship, with the consent of others, sir, I beg to mention item number 4, Lordship. Lordship, kindly fix the matter on 25th, Lordship. Learned Advocate General will appear in this case and he will argue the matter, Lordship, on 25th.
25th, maybe this bench may not be available. After 2 weeks.
And kindly fix a date, any date, Lordship.
Fix, ma'am, 25th, this bench may not be available on that.
Then any other fixed date, Lordship.
Whatever date.
Any date, Lordship, after 25th.
August. 6th of August.
Obliged, Lordship.
Wait, please, your Lordship. I beg to mention item number 9, your Lordship.
Yeah.
Lordship, will kindly adjourn the matter for a week, your Lordship.
No, I appear for the respondents, my lord. Can it be taken up next week, my lord?
Taken up
Next week.
next week.
All right.
24.
May I please, your Lordship? Lordship, I beg to mention for listing of a WPC for orders, your Lordship.
Was already filed or
Yeah,
pending?
already filed, your Lordship.
Next
It's a
week.
pending, your Lordship.
Next week.
May it please your Lordship, Lordship, I would like to mention today's daily list item number 5. The Lordship may kindly give 2 weeks time.
Adjourn.
Much obliged.
Daily list for admission, item 1.
The matter pertaining to victim compensation scheme. Lordship, kindly see the last order dated 10/6/2024.
You have filed the affidavit.
No, my lord.
No, for the state of Assam, the Lordship has directed the Chief Secretary to file an affidavit. I have received an instruction for that. I will pray for 3 days time. It is under preparation. Kindly give us
There
time.
is an affidavit on behalf of the respondent number 1.
Asalsa has filed the affidavit.
This
I-
affidavit is dated 12th of June.
No, Asalsa has filed the affidavit.
Lordship, that was filed immediately after passing of the Lordship's order. But the updated instructions, perhaps my learned friend is not.
The Chief
that-
Secretary is required to file
Yes, yes.
affidavit within time.
For the Asalsa's affidavit, I have received the copy, my lord. Yeah,
The only thing is,
my lord.
keep in mind the affidavit filed by the Assam,
Yes,
Legal
yes.
Services Authority.
Yes, my lord.
In that, they have claimed that around 40 crore rupees
Madam.
demand is pending. And from this affidavit on 12th of June 2024, you are writing that only we have already allocated 9,000, 9 crore, 9 crore, 9 crore.
That
about the
that is already given, my lord.
That is already given.
That is
but
already given.
Still, the demand is more than that.
Well, now from the affidavit which I have received today, my lord, they have filed yesterday. I have got that some fresh demand of 45 crore rupees has been given. Well, my instruction is that the affidavit is under preparation. We will file the affidavit. Kindly give us 3 days time.
Come with the specific
Correct.
proposal whether you are going to disperse that amount or not.
Definitely. True.
And you have to disperse that amount. It's not a
Lordship.
bounty.
Lordship.
These
That-
are the
that will-
people
that
who
will
are
be-
entitled for this, and the state government is required to pay for that.
Correct, my lord. My lord, kindly take it up next week.
Mr. Deena. Please. 2 days time to file. 2 days time only.
I prefer 3 days time, my lord. They have
3?
3 days time. My lord.
Okay, sir.
But till
3 days. Okay, 3
till
days time.
Friday, my lord.
To file affidavit on behalf
It
of
automatically become 5 days.
Chief Secretary of the State of Assam as directed by this court on 10/6/2024.
Lordship.
It's on Tuesday.
No. I'm not done.
Item number 2.
May I please, Your Lordship, yes, this petition is directed against an order of the learned CAT dated 6th March 2019, which Your Lordship will find at page 110.
Yes.
And Lordship, the background of the case which I would like to place before Your Lordship in a nutshell is an amount of rupees 2 lakh was released as GPS to an employee of the SSB office in Sikkim. And this draft of 2 lakh was received in the area office of the SSB in Sikkim. Thereafter, Lordship,
The 2 lakh rupees draft was supposed to be dispersed to
to an employee,
name
Lordship,
Chandra Lama.
Chandra Lama,
Chandra
Chandra Lama.
Lama.
She was an UDC at that point of time
Yes,
in the office of the area organizer SSB
this
in Sikkim.
in Sikkim. Yes,
Now, this draft was received in the office of the area organizer. Thereafter, Lordship, under the seal and signature of the respondent herein, it was encashed by another person.
name
That another person's name is Ramesh Kumar, who is not an employee of the SSB.
yes,
As a result, this particular employee, that is Mrs. Lama, she did not get the amount. And thereafter, she had filed the case before the Consumer Forum at Sikkim. Thereafter, an inquiry was made, and the respondent herein, along with another person, they returned the money
to whom?
to this lady,
To
Chandra Lama, pursuant to a case filed by Chandra Lama. And therefore, in the circumstances, Lordship, a departmental proceeding was drawn up against the respondent herein. And the articles of charge have been extracted, Lordship, in page 14, Lordship will see. 114, Lordship, page 114. That is a part of the order passed by the CAT.
yes,
That's Sri B. Bodhakur, SAO. This Baria is a place, Lordship, which he was later on transferred. Area while functioning as SAO DO of Sikkim area during the period December 2007 to August 2008, fraudulently encashed GPF withdrawal demand draft number so and so dated 27/12/2007 from SBI Gangtok directly without depositing the draft in government account, being GPF withdrawal amounting to rupees 2 lakh in respect of Srimati Chandra Lama of Sikkim area by signing the authority letter in favor of Sri Ramesh Kumar, who was not an SSB employee, which tantamounts to misconduct, unfaithfulness, dishonesty, and fraud. Thus, B. Thakur, SAO violated so and so. The second article is that, Lordship, during the aforesaid period while functioning as in the aforesaid office, the said B. Thakur, SAO, while functioning as DDO, officiating area organizer, could not ensure official procedure in dealing with incoming, outgoing drafts, resulting in missing and embezzlement of the demand draft number so and so. amounting to rupees 2 lakhs. Here, what had happened, Lordship? The DAC was received and it was not entered into the receipt book. After 18 days, in fact, the envelope contained 2 drafts. One was of 14,000 and odd rupees, which he has entered into the register book. 2 lakh draft, he has not entered in the register. And this 14,000 draft, he has entered after a period of 18 days. After a period of 18 days. Now, the third article of charge. During the aforesaid period and while functioning in the aforesaid office, the said B. Thakur, SAO, misled the office mentioning wrong date of issue of demand draft, which he collected from the PA office, SSB New Delhi, thereby he caused unnecessary delay in investigation. Lordship, this perhaps may be something, Lordship, which was not willfully done, maybe. Article 4.
Just,
That during the aforesaid
just
period,
a minute.
Lordship.
Yes. Yes.
Article 4, that during the aforesaid period and while functioning in the aforesaid office, the said B. Thakur, SAO, being DDO of the office, used to keep the cashier's key of cash chest on Sundays and kept demand drafts meant for area organizer Sikkim in his personal custody without making entry in the diary register, valuable register for considerable period, which tantamount to misconduct in violation of rules so and so. And Article 5, that the said B. Thakur SAO has paid an amount of rupees 2 lakh to Chandra Lama UBC on 10/3/2010 in presence of her advocate when a court case was under sub judice, which indicates that Sri B. Thakur SAO personally involved in this fraudulent case, which tantamount to an unbecoming act in violation of Rule 3112(3) of CCS conduct rules. Based on this, Lordship, inquiry was made and Lordship, he was awarded punishment, which your Lordship will.
Yes.
Which your Lordship will find at page
170.
This is annexure 17 in the additional affidavit, Lordship. In my, it's 117, Lordship. In the additional affidavit.
117.
In the additional affidavit, Lordship. I take your Lordship to the relevant part.
Inquiry report of departmental inquiry submitted by Apur Kumar Nath. This is what inquiry officer in respect of Sri Bodh Thakur and others. This is what the inquiry report is.
No, I'm on the impugned Lordship penalty, order of penalty.
The inquiry report is in page number 43, Your Lordship, of the same edition.
43 inquiry report. One one seven, yeah,
117 is the
penalty order.
order of penalty, and I take your Lordship to the operative part at page 123.
Yes.
Paragraph 7. Now, therefore, after careful consideration of the report of the inquiring authority, disagreement note. There was a disagreement note because the inquiry officer found some charges not to be proved, which the disciplinary authority was not in favor. There was a Lordship disagreement note. UPSC advice and the submissions made by Sri Biraj Thakur SAO. The president has decided to accept the findings of the inquiry authority disagreement note and the advice of the commission and concluded that the ends of justice would be met in this case if the penalty of reduction to a lower stage in a time scale of pay by 3 stages for a period of 5 years on the concerned officer, Sri B. Bhattakur, SAO, SSB, with further direction that the concerned officer will not earn increments of pay during the period of such reduction, and on the expiry of such period, the reduction will have the effect of postponing the future increments of his pay is imposed upon Sri Biraj Bhattakur, SAO. Now, this order was under challenge before the learned CAT. Now, if I may take your lordship once again to the order passed by the learned CAT, that your lordship will find
Yes.
at Annexure 4, page 110 of the writ petition. If I may take your lordship to from page 114, from paragraph 4 of the order.
Yes.
Srimati Chandra Lama, UDC of the office area organizer, applied for withdrawal of 2 lakh rupees from her general provident fund in December 2007. Subsequently, she submitted an application under application dated 22/11/2008 regarding non-receipt of the GPF withdrawal of rupees 2 lakh. Later on, it was found that a demand draft bearing so and so dated 27/12/2007 for rupees 2 lakh meant for payment of GPS withdrawal to Srimati Chandra Lama UDCA had been encashed at SBI Gangtok, Sikkim, on the basis of an authorization letter allegedly signed by the applicant in favor of one Ramesh Kumar. A court of inquiry was ordered by the Deputy Inspector General SSB, Rani Dala, quite so and so, to find out the facts of the case. And as a sequel, this lordship departmental proceeding was drawn up. Now, if I may take your lordship to paragraph 5.
Yes.
These charges were denied by the applicant by this reply representation dated 10/8/2011. Accordingly, inquiry was conducted and findings of the inquiry report was submitted by letter dated 30/5/13. The findings of the inquiry officer were, and that's a charge given, lordship. Article 1 not proved, 2 and 3 are proved, and 4 and 5 are not proved, that is by the inquiry officer. After the examination, the disciplinary authority, by this disagreement note dated so and so, has concluded as under. If I may take your lordship to the disagreement note for a moment. That your lordship will find in the additional affidavit, page 94.
Yes.
The disagreement note was with regard to 2 articles of charges. If I may take your lordship to page 95, the relevant portion, lordship will find in the middle disagreement note on finding of the inquiry officer on article of charge 1. Lordship has got it at page 95.
95, yeah.
Yes. Consequent upon filing of FIR in local police station by area organizers Sikkim area and subsequent filing of a case in a district consumer forum by Chandra Lama, UDC, regarding fraudulent encashment of demand draft worth 2 lakhs, Sri B. Bhattakur, SAO, Sri Vinod Agarwal, DFO, Sri Vijay Pal, SFA, and another Sri Ramesh Pradhan, driver, within themselves, without the knowledge of superior authority, decided to pay rupees 50,000 each to cover up the case outside the court. This has been testified by Sri Ramesh Pradhan, driver, in reply to question number 5 in its statement during
He
examination
paid 50,000 each to whom?
to Chandra Lama.
All these 4 persons.
Yes. In reply to question number 1 during cross-examination by Sri B. Thakur SO, Sri Ramesh Pradhan also agreed to pay the amount as and when the amount is available to him. Sri B. Thakur SO also agreed that he had paid 2 lakhs to Srimati Chandra Lama, UDC, in presence of advocate and others. Out of 2 lakhs, rupees 50,000 has been contributed by Sri Vijay Pal, which Sri Vijay Pal, however, denied. The reason given by Sri Thakur, SAO, and others are that they were harassed by the IO, local police, every now and then, and they were feeling utterly humiliated, found to be unjustified. The question here is whether a government servant will pay such a huge amount from his own saving, even though he is not involved in embezzlement of government money. Will a government servant take blame of any wrongdoing on himself despite being innocent for the fear of police harassment and fear of court? The fear of being guilty of wrongdoing haunts the person and he tries to hide his wrongdoing by subsequent acts. Sri B. Thakur SAO and the others have paid the sum of rupees 2 lakhs to Srimati Chandra Lama while to hide their wrongdoings. The reason given by them are unjustified. Sri Somarlal Begi, peon of, in his answer to question number 8, has stated that one draft amounting to rupees 2,10,000 in respect of so-and-so. Lordship can skip this paragraph. This is not related to the petitioner hearing. Respondent. Next paragraph. It is inferred that Vijay Pal, SFA, may have intended to encash DD meant for Sri K. Datta, but due to searching of the said draft by the staff of area, he had to bring the DD to the notice of the DDO. Since the authority letter, which was noticed by the inquiry officer that the figure of rupees 2,10,000 to 2 lakhs was overwritten, meaning thereby that it can be inferred that the person who encashed the DD worth 2 lakhs had the figure of 2,10,000 in his mind while overwriting. Vijay Pal was also holding the charge of dispatcher when the registered envelope containing DD was received on 5/1/2008. Lordship, I would lay stress on this part that Vijay Pal was holding the charge of dispatcher because the previous part of this paragraph does not relate to this transaction. It is to some other transaction. Sri Vijay Pal was also holding the charge of dispatcher when the registered envelope containing the DD was received on 5/1/2008 at area headquarters, Sikkim. He was removed from dispatch duty immediately on 10/1/2008 by the DDO and replaced by K. Shyam Singh, SFA. The verbal instruction to the dispatcher that the demand draft should be kept in possession of the dispatcher unless it has been seen by the DDO is irregular because the DDO will receive it, enter it into a register. The dispatcher will only take it to the bank. So the dispatcher cannot keep any demand draft with him. A demand draft should be treated as valuable, and if DDO is not available in office, the dispatcher should invariably deposit the DDO to the cashier with proper receipt. This process has not been followed, and the nexus between Vijay Pal and B. Thakur is evident.
But this is not in relation to the 2 lakh draft, draft of Chandra Lama.
No, Lordship. What I'm trying to harp upon is, Lordship, this situation might have been going on from before because Vijay Pal is also one of the persons who has given 50,000. Now, playing of online lottery by so-and-so, by Sri B. Thakur SO, Sri Vinod Agarwal DFO so may have caused financial hardship to these personnel and due to which fraudulent encashment of DD worth rupees 2 lakh. The discussion and agreeing to contribute towards payment of rupees 2 lakh to Chandra Lama, UDC, by these personnel indicates their involvement in fraudulent encashment of rupees 2 lakhs. The finding of a diary exercise copy in government vehicle in which few pages of handwriting practice in the name of Ramesh Kumar confirms the involvement of the office personnel in the fraudulent encashment of rupees 2 lakhs.
How this, what is this
Lordship,
online lottery and all this from
Lordship,
these facts from where these
this
facts
perhaps
came?
may not be, I would not stress on that, Lordship. This perhaps may not be, it is their personal thing whether they play online
No,
or not.
how he was aware about all this? The disciplinary authority came to know about this online lottery business, or is there some evidence or what?
Lordship, there is nothing on record.
And diary exercise, copy,
This
what is
diary
this?
may have been seized, Lordship, from a vehicle, but other online lottery,
How you
Lordship,
can infer about this embezzlement of rupees 2 lakh trap?
no.
Is
That,
there any evidence? Is there was any charge that he was in a bit of playing this online lottery, and on account of he suffered some
No
losses,
charge
and
is
to
there.
cover that loss, he embezzled that amount?
no charge is there, but Lordship,
Then-
Lordship will just bear in mind, he was the DDO at that point of time.
That's right.
He was the DDO.
The simple charge is that the draft was for the Chandra Lama, and he has issued an authorization letter on the basis of which the draft order is encashed in favor of Ramesh Kumar. This is what the charge.
Lordship, Lordship. And how, Lordship, Lordship will come to the next page. This here also, Lordship, the last paragraph in page 96. The payment of the amount of rupees 2 lakhs to Chandra Lama UDC by V. Bhattakur SAO in presence of advocate of Srimati so and so is treated to be a qualified admission of misconduct. In view of the averments made above, the finding of inquiry authority against the article of charge is not convincing and hence disagreed. This is a disagreement note. And insofar as charge number 5 is concerned, Srimati Chandra Lama so and so, in answer to question number 9 and 10 of her statement, has stated that she received 2.6 lakhs from B. Bhattakur SAO in presence of advocate and other office staff. She stated that she received 2 lakhs towards her missing GPF withdrawal and rupees 60,000 towards interest at the rate of 8% per annum for a period of 2 years, court fees and other miscellaneous expenditure. Sri B. Bhattakur for SAO had agreed paying rupees 2 lakhs to Chandra Lama UDC, but denied paying additional amount of rupees 60,000 to Srimati Chandra Lama during cross-examination of Sri Chandra Prasad Mishra in so and so by Sri B. Bhattakur. Sri Mishra, in reply to question number 1, had stated that 60,000 has been given to me by Sri B. Bhattakur SAO with instruction to pay Srimati Chandra Lama UTC. Accordingly, I have given the amount to her, and regarding payment of 2 lakhs to Chandra Lama UDC, the payment receipt is available with Chandra Lama. Moreover, the payment has been made in the presence of so and so. Now, on these 2 articles of charges, the disciplinary authority disagrees. Now, what the tribunal does, tribunal goes on making its own inquiry. Page 116 of the writ petition.
Yes.
In paragraph 8, the tribunal mentions about the penalty imposed. And if I may take your lordship from paragraph 9 onwards, lordship will find at page 117.
Yes.
We have carefully gone through the entire process of the disciplinary proceeding initiated, followed and concluded by the disciplinary authority. We found that there is no any serious major deviation which would have adversely affected the interests of the applicant. Some of the points raised by the applicant, such as so and so, approval of the minister, home affairs not taken, all these points have been negated in the paragraph. Last 3 lines, we find no merit in the points raised by the applicant in regard to the procedure being adopted for initiation and finalization of the departmental proceedings. However, next page, at page 118, in regard to the merit of the charges which have been consistently and vehemently denied by the applicant, we are compelled to examine this aspect in the relevant context. This is particularly imperative in the context of the fact that three authorities, namely the inquiry authority, the disciplinary authority, and the advisor, that is the UPSC, have found the article of charges with different conclusions on the same materials as hereunder. The UPSC lordship comes in because this applicant happens to be a grade 1 officer. Therefore, the views of the UPSC has been taken. And the tribunal discusses the proceedings, each charge separately from paragraph 10. Article 1 of the charge is that the applicant has committed grave misconduct by fraudulently encashing the GPF withdrawal and demand draft dated so and so amounting to rupees 2 lakh from SBI Gangtok. Charged in Article 2 is that applicant, while functioning as officiating area organizer, would not ensure official procedure in dealing with incoming and outgoing ducts resulting in missing and embezzlement of demand draft dated 27/12/2007 amounting to rupees 2 lakhs. The plain reading of these articles of charge, the first charge may look genuine and straightforward, but adding charge of Article 2 makes it very strange and perplexing. Now, lordship, how a charge has to be framed or is framed, that is left to the disciplinary authority. Charge 2 makes it very strange and perplexing. In Article 1, the charge is that the applicant had fraudulently encashed the demand draft. But in Article 2, the charge is that he could not ensure official procedure in dealing with incoming and outgoing ducts, resulting in missing and embezzlement of demand draft as if somebody is charged of actually having done fraudulent encashment of the said demand draft and not by the applicant. By instituting these two charges together against one person, it appears as if somebody has been driven into a tunnel wherein both ends tunnel traps have been laid to catch hold of him. These two articles of charges accordingly are found to be contradictory in nature and against the principle of fairness and natural justice. If any one of them is charged, it would have looked simple and genuine, whereas putting them together as independent but combined charges are found to be unfair and unsuitable. Now, the tribunal is not to say how the charge has to be framed. As it is, lordship, the demand draft was received on a particular day. It was entered, the envelope was entered into the records after 18 days. An authority letter was issued under his signature and stamp, which he denies. Now this stamp, this authority letter pads are in his custody. Therefore, the charge number 2 will come. As regards the charge number 3, this is found to be frivolous. And the applicant has been made to explain adequately and convincingly. But it may also be added that the mistake committed by the applicant appears to be quite genuine. And he has been able to substantiate it with detailed explanation. This is with regard to that, lordship, the date of issue of DD, which I also said that he might have inadvertently made a mistake in collecting a date. I will leave paragraph 11. Paragraph 12. As regards the charge under Article 4, all these authorities found not proved. Accordingly, further judicial scrutiny on this point of charge is considered not necessary. That's fine. As regards charge under Article 5, it appears that this is the main article under which the applicant has been finally found to be guilty of misconduct. In this connection, it may be recalled that the applicant consistently and vehemently denied the charge of having fraudulently encashing the said demand draft the applicant claimed that there was no need for fraudulently encashing the demand draft for him when he has all the official power to encash the demand draft as authorized DDO. If he encashes the demand draft, Lordship, as authorized DDO, naturally he will be caught. On this point of argument, it is acceptable that he could have withdrawn the money officially and still denied payment to the lady, that is Srimati Chandra Lama, UDC, by manipulating the records in his own office. However, this is not the point of the charge. The point of charge is that he had encashed the demand draft fraudulently and has not paid the amount to the beneficiary. We have looked at the certified copy of the demand draft number so and so. It is recorded as a demand draft in favor of the area organizer SSB Sikkim. This means that the demand draft is supposed to be credited in the current account of the office of the area organizer SSB Sikkim Gangtok. This amount supposedly to be withdrawn again through checkbook issued by the bank and payment made to the beneficiary after making necessary recording, obtaining of her signature. This has not been done. The demand draft has been directly allowed to be encashed by the bank as well, in spite of being a heavy amount. This was purportedly on the strength of the authority letter issued, letter dated so and so, in favor of the person named Ramesh Kumar. Now, when the seal and the authority pads are in the custody of the DDO, he has definitely to be held liable. Now, the crucial point is, who has authorized the so-called Ramesh Kumar to encash the demand draft? The specimen signatures of the applicant, namely Biraj Botagur, and the signature as appears in the letters so and so to the OA has been sent to the Forensic Scientific Laboratory at Kolkata by the police authorities for the assessment and the opinion of the report. The scientific authority, that is the Forensic Science Laboratory, has conveyed as under, not a conclusive finding. Next page, Lordship. It is observed that after this route has been blocked by the scientific expert opinion. Now, Lordship will just for a moment pause. After this route has been blocked by the scientific opinion, scientific expert opinion, Lordship, is the tribunal. What is the tribunal trying to say? It is arguing a case. Probability of getting the point of the charge proved gets shifted to the domain wherein the applicant along with others have paid rupees 2 lakhs to Srimati Chandra Lama. That they have paid rupees 2 lakhs and 60,000 that has come. That is not disproved. They have paid. And when they have paid, after a court case was filed. The averment is that since the applicant had agreed to pay the amount to the beneficiary, it has been concluded by the respondent authorities that he has admitted to have committed the misconduct of having fraudulently withdrawing the said demand draft. The charge now gets shifted from the principle of direct evidence to the principle of preponderance of probability. Now, Lordship, when it is a departmental proceeding, it is always preponderance of probability as the basis of proving the charges, which is, of course, considered to be adequate to establish the charge in a departmental proceeding. However, putting the things in proper sequence, shifting the basis of proof from scientific to the preponderance of probability is considered to be highly unfair to the charged official. Now, I'll continue, Lordship. Highly unfair to the charged official. It appears as if the charged officer is somehow targeted so much so that after having failed to prove on the basis of expert scientific opinion, one has shifted to the principle of preponderance of probability. In fact, the applicant also has adequately explained in his representation date so and so against the statement of article of charge framed under against him, which wherein he is recorded as under. It is submitted that simply because under compelling circumstances, I also contributed towards compensating to the financial loss of a junior staff of mine, which loss occurred during official transactions between the PAO New Delhi and the AO office Gangtok. No, Lordship, not PAO and New Delhi and AO office Gangtok. The draft had reached Gangtok. It was only after that it went missing, or maybe it was kept hidden and thereafter it was kept encashed by a third party. This cannot be and must not be construed in law that I am involved in the alleged offense. Now, the tribunal goes on a spree as if it is deciding a criminal case, Lordship, suspicion. And finally, Lordship, at paragraph 17, considering the above and circumstances and the nature of articles of charges, among which particularly 1, 2, and 5 are contradictory to each other, and also the fact that restricted point of the charge is basically fraudulent encashment of the said demand draft, we found that the respondent authorities have not been able to prove the charge leveled against the applicant. It is liable to be set aside. Accordingly, so and so, imposing penalty is hereby questioned, set aside. Now, once the tribunal has come to a finding that the penalty imposed is not correct, what would it do? The fact that rupees 2 lakh worth of a demand draft has been encashed, and that too on a pad under the seal of the respondent, it cannot be said that he is totally innocent, Lordship. At best, the tribunal could have remanded it back.
Yes.
And so far as Lordship, the law on this point would be concerned, I would just refer to a judgment of the Honorable Supreme Court in BC Chaturvedi versus Union of India and others. If I may take your Lordship to page 7 of that. If I may take your Lordship to page 7 of that judgment. Yes, Lordship.
Yes.
Lordship, I would be referring to paragraph 17 and 18 of this judgment. If I may read out, Lordship. Lordship will find at page 7. The next question is whether the tribunal was justified in interfering with the punishment imposed by the disciplinary authority. A constitutional bench of this court in state of Orissa versus Vidyabhushan Mahapatra held that having regard to the gravity of the established misconduct, the punishing authority had the power and jurisdiction to impose punishment. The penalty was not open to review by the High Court under Article 226. If the High Court reached a finding that there was some evidence to reach the conclusion, it became unaccessible. The order of the governor, who had jurisdiction and unrestricted power to determine the appropriate punishment, was final. The High Court had no jurisdiction to direct the governor to review the penalty. It was further held that if the order was supported on any finding as to substantial misconduct for which punishment can lawfully be imposed, it was not for the court to consider whether the ground alone would have weight with the authority in dismissing the public servant. The court had no jurisdiction if the findings prima facie made out a case of misconduct to direct the governor to reconsider the order of the penalty. This view was reiterated in Union of India versus Sardar Bahadur. It is true that in Bhagat Ram versus State of HP, a bench of 2 judges of this court, while holding that the High Court did not function as a court of appeal, concluded that when the finding was utterly perverse, the High Court could always interfere with the same. In that case, the finding was that the appellant was to supervise, it should be felling of trees, which was not hammer marked. The government had recovered from the contractor the loss caused to it by illicit felling of trees. Under those circumstances, this court held that the finding of guilt was perverse and unsupported by evidence. The ratio, therefore, is not an authority to conclude that in every case, the court tribunal is empowered to interfere with the punishment imposed by the disciplinary authority. In Rangaswamy versus State of TN, a bench of 3 judges of this court, while considering the power to interfere with the order of punishment, held that this court, while exercising the jurisdiction under Article 136 of the Constitution, is empowered to alter or interfere with the penalty, and the tribunal had no power to substitute its own discretion for that of the authority. It would be seen that this court did not appear to have intended to lay down that in no case the High Court tribunal has the power to alter the penalty imposed by the disciplinary authority or the appellate authority. The controversy was again canvassed in State Bank of India case, where the court elaborately reviewed the case law on the scope of judicial review and the powers of the tribunal in disciplinary matters and nature of punishment on the facts of the case. Since the appellate authority had not adverted to the relevant facts, it was remitted to the appellate authority to impose appropriate punishment. A review of the above legal position would establish the disciplinary authority and on appeal, the appellate authority, being the fact-finding authorities, have exclusive power to consider the evidence with a view to maintain discipline. They are invested with the discretion to impose appropriate punishment, keeping in view the magnitude or gravity of the misconduct. The High Court tribunal, while exercising the power of judicial review, cannot normally substitute its own conclusion on penalty and impose some other penalty. I am not on some other penalty, but the tribunal has imposed its own view. It has made an inquiry by its own. If the punishment imposed by the disciplinary authority or the appellate authority shocks the conscience of the High Court tribunal, it would appropriately mold the relief, either directing the disciplinary appellate authority to reconsider the penalty imposed or to shorten the litigation. It may itself, in exceptional and rare cases, impose appropriate penalty with present reasons and support thereof.
Yes.
In the instant case, Lordship, what the tribunal has done, it has discussed all the issues, how we have gone about, how we have arrived at a satisfaction. This is contradictory to that, that was not the duty of the tribunal, lordship. I would lay my case on that.
May I please step up, Lordship. Lordship, the case, as far as the factual elements are concerned, my learned senior has already explained the facts. Simple fact, your Lordship has also noticed. A draft came to the office, to my office, where I was a DTO. This draft got stolen. And there is also an authorized letter.
Stolen,
Not embezzled. The word here used is embezzled. That's why
stolen,
it's different.
altogether different.
Lordship. This draft got lost in the process, and then I was also given the allegation is I gave an authorization letter to one third party, and that third party, now obviously it would be that the third party went with the draft and the authorization letter which I purportedly gave
Encashed that draft.
and encashed the draft, Your Lordship. So the link is that whether I gave the authorization letter. That is the link, Your Lordship. Now, for that, I have given evidence before the inquiry officer, the forensic laboratory, which has been stated here, Your Lordship. Lordship, to that extent, Your Lordship will kindly turn to my affidavit in opposition, page number 15, Your Lordship. It starts from page number 12, the opinion, etc., but page number 15 is the main thing, Lordship. The document in this case has been carefully and thoroughly examined. Second point is the most important one. The person who wrote the blue enclosed signatures stamped and marked S1 to S5 did not write the red enclosed signatures. Similar,
Ramesh Kumar was examined during the proceeding.
no, he could not be found, Your Lordship, Ramesh Kumar, because that person is not here, Your Lordship. Some unknown person was there. That's the thing, Your Lordship.
Ramesh Kumar was examined or not?
No.
He was examined.
Ramesh Pradhan, the driver, was examined, Your Lordship.
Ramesh Pradhan.
The driver.
Driver was examined. He was the person who encashed the check.
No. This is the unknown third party, Your Lordship. This is not
Ramesh Kumar.
This is Ramesh Kumar. He's an unknown. The allegation is that I was I gave this to a third party with my authorization letter, and the third party also could not be apprehended or anything else. He's out of the picture in a way.
What happened in the police case?
Plus, it was final closure report was given, Your Lordship.
On account of that compromise.
Could not, no, not on account of the compromise. No evidence could not be found, Your Lordship. That way, Your Lordship. Your Lordship, so Your Lordship will kindly turn to page number 18. This where all these Q4, Q5, S5, all these things were given, Your Lordship. This is actually the authorization letter. Page number 18. This is the authorization letter.
What is your reply?
My reply, affidavit in opposition, Your Lordship.
Before the disciplinary, during course of inquiry.
Lordship, this is in the additional affidavit. This is in the written statement of defense, Your Lordship. Page number 8 of the additional affidavit, Your Lordship. Page number 9, I have denied, Your Lordship. These documents, Your Lordship, were not out of the inquiry, Your Lordship. These were letters which I sent to the inquiry. These were to the inquiry officer during the inquiry, Your Lordship. The document which I just showed to Your Lordship.
This explanation,
Lordship,
since the charge of embezzlement was against you,
Lordship.
why this driver and Vijay Pal and they agreed to pay 50,000? There was no charge against them.
Lordship, no, this was a joint proceeding, Your Lordship. With three other people, Your Lordship.
Lordship will find that at page 43, the report of the inquiry officer.
Yes.
Lordship, that is, firstly, I wanted to stick to this, Your Lordship, page number 15, which the opinion which I've shown. Point number 2, the person who wrote the blue enclosed signature stamped and marked S1 to S5 did not write the red enclosed signature similarly stamped and marked Q1, Q6, and Q9. Page number 15 of the affidavit in opposition, Your Lordship.
Yes.
Third line is, it is not possible to express any opinion on the rest of the items. Rest of the items, we are also not concerned with, Your Lordship. We are only concerned with the authorization letter, whether this authorization letter was actually signed by me. If I would have signed this authorization letter, then my guilt would have been there, Your Lordship, that there is a link when I gave it to someone and I gave the authorization letter also. But I did not give the authorization letter, Your Lordship. And for that, Your Lordship will see this Q4, Q5, this is what exactly what the person is saying, Your Lordship. Q1, Q6, these are not my signature. So what?
Somebody in your name has produced a forged or fake authorization
Exactly.
letter and got the money encashed in his favor.
Exactly, Your Lordship.
What
So
action you have taken against that?
I was not even aware about this, Your Lordship. Later on, at the fag end of when the controversy erupted. In fact, I was also
Then, even though after knowing this, that somebody has fraudulently or prepared a fake authorization letter
Lordship.
in your name,
Lordship.
what action you have taken?
Lordship, in fact, I was the one who had sent some people to the main head office to find out what happened to the DDO, to the demand.
There are 2-3 circumstances.
Lordship.
You were the officer in charge or whatever it may be, you were the hem of the affairs at that time.
Lordship.
Some draft came into your office that was not that was inverted or whatever it may be in the Delhi register.
Hmm.
Later on, it was inverted or something. Thereafter, you came to know that this draft was encashed by some person under a authorization letter purportedly issued by you. Thereafter, you agreed to pay the amount and actually you paid the amount. These are the things which
I understand.
in the mind of
Lordship,
a
but,
person, why
Lordship.
a person at that time, it was in 2007 or 8, 2 lakh was not a small amount.
Small amount, yes. Lordship, but that is the bane of my existence. That has precisely what has happened. I have explained in my written statement, perhaps Your Lordship has seen also. why I have given,
Immediately after knowing this, that somebody has encashed that draft under your, under the authorization letter purportedly issued by you, you not taken action, you should have taken action, you filed an FIR, this was the fourth one, sir.
Lordship, no, there is something, but it is not, I have not stated in the affidavit here, but I remember because in discussing the case that he was the one who had sent it. I think in the inquiry report also something was there, or in my written brief. I had given something of this nature that, okay, I sent people repeatedly there. What happened thereafter, when I came to know also, I participated. In fact, I was transferred and then this happened, but I cannot say directly, Your Lordship, without looking at the document.
Record.
Yes, exactly, Your Lordship. That is why I cannot say it so certainly, Your Lordship, but it is not that I sat silent and all, Your Lordship. In fact, I sent it to through.
The tribunal, in fact, has gone into deep into the matter as if for the first time they are dealing with the evidence available on record.
Lordship, only two things are there which the tribunal has looked into in my respectful submission, Your Lordship. One is this opinion, which categorically proves my non-involvement.
Opinion may not be there, but that itself.
And secondly, Your Lordship, this charge, so far as this opinion is there, Your Lordship, this actually shows that I was not involved. I was actually the victim here also, because precisely because of this reason that now I'm now being looked into with this eyes, Your Lordship. So far as this why I paid the money is concerned, Your Lordship has possibly read, but I would also like to reiterate why. Basically, Your Lordship, everyone advised me that okay, you compromise the matter.
That you agreed to pay the amount without even resisting for a moment.
No, it was not like that, Your Lordship. I resisted.
Not registered.
Your Lordship, let me read the page number 15. This is my written statement of defense.
Yes.
Article 5 that said Sri Biraj Borthakur fraudulently encased the demand draft amounting to this and later on paid the same amount to Chandra Lama in presence of an advocate when a court case was sub judice. Reply: in reply to the above charge, I deny the charges. I deny that I had fraudulently or otherwise encased the demand draft number so and so amounting to rupees 2 lakh, being payment of GPS withdrawal in respect of Sri Chandra Lama. In fact, an amount of rupees 2 lakh was paid to Sri Chandra Lama judicially not by me alone but along with Sri Vijay Pal. As to why and under what circumstances the said amount was paid to Sri Chandra Lama is explained below, Your Lordship.
This reply you filed in
Inquiry to the
date.
not said. Date 10/8/11.
10/8/11.
To the charge sheet, reply to the charge sheet, Your Lordship. As Sri Chandra Lama UDC did not receive a GPF withdrawal amounting to rupees 2 lakhs, she filed a case before the District Consumer Redressal Forum, Gangtok, Sikkim. An FIR was lodged at Gangtok Sodar Police Station, Gangtok, in respect to the missing of the above demand draft in question. The Gangtok police started questioning almost everybody in a Gangtok office, including myself, repeatedly. I started feeling utterly humiliated. I had an absolutely unblemished and clean career for the last 26 years in the department. In fact, for my sincere and honest hard work, I was conferred with a certificate of commendation by the Director General SSB in 2006. My wife, who is a lecturer in a high secondary school in Assam, came to learn about this incident and being worried, started calling me and being worried, stuttered, call me up every now and then. Myself and my wife felt harassed and mentally depressed. I was also feeling sorry for the plight of Sri Chandra Lama. Sri V.K. Agarwal had asked the IO of the case in my presence as to how the case can be closed, Your Lordship. Then the IO told him that if he could manage to deposit an amount of rupees 2 lakh, then IO would close the case and otherwise not, Your Lordship. Basically, an attempt to compromise and etc. was done, Your Lordship. Thereafter, V.K. Agarwal discussed the matter with Ramesh Pradhan and myself about depositing 2 lakh by sharing 50,000 each. In the meantime, I had already been transferred to Barrage and I was being called by the IO every now and then, and it became harassing to me to make journey every now and then to Gangtok and back, Your Lordship. Considering the physical harassment, mental tension, I agreed to pay 50,000 for closing the case, but ultimately only Sri Vijay Pal and myself had to bear the burden of depositing 2 lakh. Vijay Pal paying 60,000, I paying 1,40,000. Though Sri Ramesh Pradhan and V.K. Agarwal ultimately told us that they were not having ready cash in the case, they requested to pay the entire amount of the share as well, and that they would pay us back later on. It is respectfully submitted that under the above compelling circumstances only I paid and cashed the demand after rupees 2 lakh, Your Lordship. Lordship, the entire
And
thing.
the complainant says that you also paid the amount of rupees 60,000 as interest.
Lordship, that is, I have said this much, Your Lordship. I have never said that I have paid 2,60,000 or something, Your Lordship. And in that case, the charge should also have indicated that I paid 2,60,000 or something of that nature, Your Lordship. That was not done, Your Lordship. Lordship, my second point, I'm only limiting myself to the 2 points which the tribunal had said, Your Lordship. The tribunal looked into this evidence of the authorization letter, Your Lordship. Second point, Your Lordship said, the tribunal which stressed on was the conflicting charges, Your Lordship. May I, Your Lordship, read the charges again, Your Lordship? That Shri Biraj Bhattakur SAO Barrage area well functioning as SAO DDO of Sikkim area during the period of December 2007 to August 2008 fraudulently encashed GPF withdrawal demand draft number so and so from SBI Gangtok directly without depositing the demand draft in government account being GPF withdrawal amounting to rupees 2 lakh in respect of Chandran Lama of UDC of Sikkim area by signing the authority letter in favor of Shri Ramesh Kumar, who is not an SSBI employee, which tantamount to misconduct, unfaithfulness, and dishonesty and fraud. Thus, Shri Biraj Bhattakur violated rules so and so. Article 2. That during the aforesaid period, while functioning in the aforesaid office, the said Shri Biraj Bhattakur SAO, while functioning as DDO officiating area organizer, could not ensure official procedure in dealing with incoming and outgoing ducts, resulting in missing and embezzlement of the demand draft. Lordship, this line is very important. That's why I'm waiting for your lordships.
Yes.
Lordship, Article 2. That during first one was relating to fraud, I said for the allegation. Article 2, Your Lordship. That during the aforesaid period and while functioning in the aforesaid office, Your Lordship, the said Sri Biraj Bhattakur, while functioning as DDO officiating area organizer, could not ensure official procedure in dealing with incoming outgoing ducts, resulting in missing and embezzlement of the demand draft.
That is altogether a charge which was not supposed to be framed. They have simply said that during that procedure, you are not following the procedure, and on account of that, this
resulting in theft and embezzlement of the charge. And I was held guilty of both.
How the tribunal came to this conclusion that these charges are contradictory to
I will
each other,
explain.
and they investigated in such a manner. Don't know.
Lordship, I will explain. My humble submission in this regard is as follows, Your Lordship.
Yeah.
First one denotes fraud and
First charge was very much clear.
clear, exactly. Second charge was about negligence. Now,
That's right, and that has not been proved.
no, I have been found to be guilty of this. That is exactly the point, Your Lordship. Your Lordship will see the inquiry report. Inquiry officer did not find me guilty of the charge number 1 and 5.
Yeah.
Inquiry officer did not find me guilty of charge number 1 and 5. Because he realized this self-contradictory, presumably he realized the self-contradictory nature of the charges, so he did not find me guilty. Then the disagreement note came, Your Lordship. And disagreement note, Your Lordship, will kindly turn to page number 96.
Yes.
It has been read, but I would like to read again, Your Lordship. Of the additional affidavit, Your Lordship. Your Lordship has.
Yes.
The entire point is that I cannot be held guilty of a same transaction of fraud and negligence at the same time, Your Lordship. I wanted to give an example before, Your Lordship, because this is what I was going through my mind.
That was an isolated case. And that was a case of embezzlement. Whereas the second charge was general in nature, that while working as the CEO or whatever the post you were holding, you were negligent.
Lordship, that is why I wanted to read the specific word.
Yes.
Resulting in missing and embezzlement of the demand draft number so and so dated so and so.
So missing, nobody's case is that the demand draft was missing or the demand draft was missed.
Yeah,
That
that
was
is that.
nobody's case.
No, someone took it. So someone must have taken it, Your Lordship. So that's someone who took
So
it.
only someone took it from your custody and you have not been complained against that, sir. Instead, you paid the money.
I paid the money because of the explanation which I've given, Your Lordship. But the thing is that this is the thing that is operating in the mind of almost everyone, Your Lordship. That is why I'm giving page number 96 another read, Your Lordship. The question here is whether a government servant will pay such a huge sum from his own saving, even though he's not involved in embezzlement of government money. Problem here is that, Your Lordship, these are not proven facts. I have proven the fact that the authorization letter was not given by me. But these are all.
In fact, they failed to prove.
Yes.
You have not proven the fact.
I
You
have.
have simply denied. I have not issued any such.
Lordship, true, but I have given this in my evidence before the inquiry officer that look, this authorization letter was not signed by me. So what do they do with this, Your Lordship? Then they say that no, because you gave the money, therefore you must have been guilty. There must be something in your mind. This is the thing. But Your Lordship, then what happens to the authorization is that they fail to prove. What happens to that? They cannot prove that because the charge here is that 1 and 5, the charge here is that I gave an authorization letter because of which the entire thing happened. I did not give the authorization letter. So what happened, Your Lordship? So this is the thing. Your Lordship, I understand what Your Lordship is asking that, okay, if you're innocent, why did you give money, Your Lordship? But frankly speaking, Your Lordship also knows that in certain cases, in compromise cases, in police cases, Your Lordship may not be able to take judicial notice of this.
If there is a dispute, then compromise. There is no dispute.
Your Lordship will see his name was there in the police case, and also that's why he had to settle the matter. That's a separate issue, Your Lordship. But my entire thing is that if they have been able to disprove, not proven, I have been able to prove that I did not sign the authorization letter, then how come? Because charges are almost like mathematical things. 1, 2, 3, 4, the whatever has been given, you have to prove it. Now, if they could not prove that I gave the authorization letter, then what happened to how can I be held guilty of 1 and 5, charge number 1 and 5? That I've been held guilty of charge number 1 and 5 precisely on the basis of surmise and conjecture. that, okay, if you are innocent, why did you give 2 lakh rupees? Therefore, you must be guilty. To use a Hindi expression, your lordship, dal mein kuch kala hai, so you must be guilty, your lordship. So that is the thing, your lordship.
दाल में नहीं पूरी दाल ही काली है
Oh,
दाल में काली नहीं, दाल ही काली
so that's the thing, your lordship. But the problem is, this is all surmise and conjecture. Whereas I have been able to prove with documents that I did not sign the authorization letter. Then where does my culpability come in under 1 and 5? If you say that, okay, because of my negligence, the embezzlement of the Niban draft could happen, okay, fine. Not fine in the sense, but still, I can understand this fact. But how about 1 and 5, your lordship? These have to be proven with a mathematical precision that, okay, I gave the authorization letter. Where is that proof that I gave the authorization letter resulting in the fraud, your lordship? This is my humble submission, your lordship, because this is one of the focal point of the case. Entire thing is precisely what your lordship is also thinking, what they were also thinking the same thing. Okay, you have given the money, so you must be guilty. You have given the money, so therefore you must be guilty.
This is not the thinking of the court. In fact, it creates a serious doubt. It's a human nature.
Lordship.
You will also say, if you are not representing this person,
Not
certainly you will
exactly,
also
your
upset.
lordship. But that
So whatever, why you have paid the money when you have not embezzled that amount? And it's not a small amount.
true, your lordship, but that is the issue. There's a difference between how a common man thinks and how a disciplinary authority is supposed to think, your lordship. This is where the issue is. Your lordship, this 96, page number 96, first para.
Is also a human being.
But he has to be not merely a human being, a reasonable human being, and has to see it from that perspective, your lordship. My humble submission is that, your lordship, the stronger the charge, the more it has to be proven to the hilt, your lordship. And for that to happen, your lordship, at least for so far as the authorization letter is concerned, that they have not been able to prove.
Is it not a case of negligence on your part that a demand draft was received in your office and it was encashed by some unauthorized person without there being any authority letter issued by you? Is it not a case of negligence?
Lordship,
You are ultimately dealing with the public money.
I was very fair also in submitting that also, your lordship.
Yeah.
In the written statement of defense, perhaps your lordship has gone through.
Yeah.
Maybe the result of mishandling by any of the officers in a dispatch register, and as per neither put up.
You were the office, you were the in charge of the office.
Lordship, as a common man, I would say that, okay, your lordships are.
Is it not, sir, the people are having faith in the institutions.
Lordship.
That certainly if the money what they are entitled is in your custody, and if
Absolutely.
that money is embezzled or by somebody else, who is responsible for
I am
it? You say that I have not done it and therefore I can't be.
That is where the issue. That is where the lordship, the tribunal has also stated that had it been stayed till that, then it would have been okay. Had it been that, okay, you're negligent.
Ultimately, the punishment is of not of this penalty was not of dismissal or retirement or whatever it may be. It's simply an imprisonment.
But your lordship, this creates a stigma that you have committed a fraud. Fraud is something, your lordship. Lordship, there's a difference between fraud and negligence. Okay, negligence may be because, okay, we can go to that extent of saying that, okay, there may be some negligence. I was not.
So negligence which resulted into loss to a person,
Lordship.
will it not amount to misconduct?
Lordship, in this case, as you.
Where are the bank regulations? The bank regulations.
Bank?
The charges were proved under disciplinary rules which.
CCA rule, your lordship.
CCA rules. Give us the copy of that CCA rules. Nineteen 65.
Lordship, I'm very sorry to interrupt. May I say one thing? Lordship was asking about what did you do? What action did you take, Your Lordship, about the fact that this was taken, Your Lordship? In that case, Your Lordship will turn to page number 4. If you're after looking into this book, Your Lordship may turn to page number 40 of the writ petition, Your Lordship.
Yeah, read.
Lordship. It's a slightly long paragraph. This is a paragraph from my original application filed before the Honorable Tribunal, Your Lordship. Learned Tribunal, Your Lordship. That Srimati Lama UDC wanted to withdraw rupees 2 lakh from her GPF account, and the applicant as the DDO completed the official procedures, signed the bill on 5/12/2007 and sent it to the PAO, that is Pay and Accounts Office of SSB at New Delhi. When the demand draft DD for the same did not arrive, the applicant even requested one Sri VK Sharma, SFA-M of the same Gangtok office, who was at that time in Delhi, to go to the PO and ensure that the said bill of Sri Lama was passed. Sri Sharma informed on February 2008 that the bill had already been passed and had been dispatched already. In fact, the DD of rupees 2 lakh was dispatched along with another DD of rupees 14,718 through speed post. The applicant checked the relevant registers of the area office Gangtok, but there was no sign of the second draft of rupees 2 lakh being received. So though the other draft of rupees 14,718 was shown as received. Apparently, the envelope purportedly containing the 2 drafts was received in the office on 5/1/2008, but the said draft of rupees 2 lakh went missing or could not be traced out. Since Srimati Lama did not receive the DD, the applicant made inquiries in the post office, which proved to be inconclusive, and later on even sent various messages to the PEO SSB in New Delhi to prepare new draft, but got no reply. The applicant as the DDO of the office had the power to issue authorization letter, allowing some other office staff to withdraw money from the bank. In fact, unknown to the applicant, some persons had forged the signature of the applicant in an authorization letter dated 4/2/08, allegedly authorizing one Sri Ramesh Kumar to encash the said DD of rupees 2 lakh from the bank. Using this fraudulent authorization letter, the offenders had already encashed the DD of rupees 2 lakh from SBI Gangtok. The applicant came to know of this much later. At this juncture, it may be apposite to mention that the subsequently FSL report was also sought regarding the authenticity of the authorization letter allegedly written by the applicant, authorizing the said Ramesh Kumar to encash the DD of 2 lakhs, and this report found that the signature in the authorization letter did not match the applicant's signature. Since the applicant was still in the dark about the aforementioned nefarious events at this point in time, he even deputed one other office staff, Sri Vijay Pal, specially to the PEO SSB New Delhi to inquire about the DD, but he informed the applicant that there was no record of the said DD of rupees 2 lakh. Then on the 7th and 8th of June 2008, the applicant had gone to New Delhi to attend an official conference, and there he himself went to the PEO SSB to inquire about the DD, and he was able to trace out the record of the DD, and he came to know that the DD was prepared and dispatched as per PEO's issue register on 31/12/2007. The applicant was advised at the PEO to get letter from Drawing Bank, that is SBI Gangtok, that the said DD of 2 lakh was not encashed, and only then a duplicate bill could be issued. Thereafter, on his return, the applicant even made relevant inquiries in the bank, but the bank informed him that no such DD was encashed from it, provided the number and date of the DD was correct, and the applicant conveyed the same to the PEO Delhi. This is where this wrong collection of date, which my learned senior friend was referring to, came into the picture, Your Lordship, because I felt that I can show from the documents also what has gone on. He received no suitable reply from the PEO till his transfer to Bahrain, UP, Your Lordship. So what happened is that, so once he did not get the reply, then only all this controversy erupted once he had already gone out of the Gangtok office, Your Lordship. That is page number 40 and 41 of the affidavit in opposition, and this is the part of my OA, Your Lordship, original application, Your Lordship. And so far as
Lordship will kindly see my reply before the tribunal so far as this paragraph is concerned. Lordship may come to page 80.
Yes.
He was referring to paragraph number 4.5 of the OA. He says he was doing all the running about, he did not know anything. Now, from where did the report of the forensic come? There has to be a police case, and that forensic report, so far as the handwriting is concerned, that will not help him in any manner so far as the DP is concerned. That is for the criminal investigation part. Now, if your lordship will come to page 80 of the writ petition. So far as reply to his paragraph number 4.5 is concerned, lordship will find out that paragraph 5 at page 80. That with regard to the statements made in paragraph number 4.5 of the original application, the answering respondent denied the averment made by the applicant. It is submitted that the applicant was holding the charge of DDO with effect from September 2004 to 18/8/2008 in the office of the area organizer, Sikkim. The demand draft number so and so dated 27/12/2007 pertaining to GPF withdrawal of Srimati Chandra Lama. UIC area office Sikkim was fraudulently encashed on 4/2/2008. The applicant was also holding charge of the officiating area organizer with effect from 18/8/2007 to 15/2/2008. That is the time of the fraudulent encashment and embezzlement of the demand draft for Rs 2 lakhs pertaining to Srimati Chandra Lama UDC as Sri A.K. Nath JO Sikkim was on attachment duty outside. Next, consequent upon filing of FIR in local police station by the area organizer Sikkim area and subsequently filing of a case in the district consumer forum by Srimati Chandra Lama UDC regarding fraudulent encashment of demand draft for 2 lakhs. Sri Viraj Thakur paid rupees 2 lakhs to Chandra Lama UDC in presence of advocate and others. As per statement of the applicant, out of rupees 2 lakhs, 50,000 has been contributed by Sri Vijaypal SFA, which Sri Vijaypal, however, denied. The reasons given by Sri Thakur's SAO are that he was harassed by the inquiry officer local police every now and then, and he was feeling utterly humiliated, which was found unjustified. The findings of the CFSL Kolkata does not absolve the charged officer of his involvement on fraudulent encashment of demand draft was rupees 2 lakhs. The findings of a departmental inquiry in accordance with PCA may not be based strictly upon evidence. However, preponderance of probability is adequate to establish the charge in a departmental proceeding. Next paragraph. Payment of amount of rupees 2 lakhs to Srimati so and so by Viraj Thakur SAO in presence of advocate of Srimati Chandra Lama UDC is treated as a qualified admission. Now, the document at page 15, which my friend is strongly relying upon, was a report from the Directorate of Forensic to the police. It is not an outcome of a case or a complaint that he has lodged. He did not take any steps. He did not take any steps. In fact, when the case was there, he came to know about this. He paid the bill. That is my submission, Lordship.
Lordship, there's one last submission which I would like to make.
Yes.
Uh, Lordship will turn to page number 43, that is the inquiry report.
Yes. Just a minute.
Yes,
Lordship, this is one last point, which this is the one point which is not there in the judgment, your lordship, of the impugned order, which is not there, but I still want to raise this point, your lordship. Page number 43 is the inquiry report. Lordship will come to page number 93, last page of the inquiry report.
last page of inquiry report.
Lordship, it should be 93, your lordship, page number 93. Yes.
Yeah.
Lordship has seen that the findings, Article 2 of the charge, that he did not collect any information from PO against her, is proof. Thereafter, there is an enclosure. Enclosure, your lordship. Now, lordship will see at the very bottom, the page is 51 of 67. So this is the 51st page. So this enclosure runs to 33 pages. So 51.
Yeah, enclosure, brief statement of case, disciplinary authority, 33 pages.
So that should be 51 plus 33 pages. So something around 84 pages it should be, your lordship. But that enclosure was not given to me. I can prove it from the documents itself, your lordship, that your lordship.
That was not your case before the tribunal. even.
I had mentioned this here. It was there. It is an argument of mine, your lordship. I can show it from the OA as well as the. This is that is lordship. I wanted to. That is why I said that this was not mentioned in the.
Yes.
Lordship, this I have mentioned in para 4.15 of my original application, your lordship. I'll read the para, your lordship. That thereafter the inquiring authority prepared his inquiry report on 27/7/2013, holding only Article 2 and Article 3 of the charge sheet to be proved and rest as not proved. However, after a gap of almost 1 year, on 14/7/14, the Assistant Director, Pers 1, SSB, Director General, New Delhi, issued a disagreement note, ostensibly by order and in the name of the President. He issued a memorandum under number so-and-so dated 14/7/14, addressed to the area organizer, SSB Barrage area, directing him to hand over another memorandum issued to him to the applicant under number so-and-so dated 14/7/14, 1 page, disagreement note, 4 pages, and inquiry report, 51 pages.
Yes.
Total 56 pages. However, it is evident from the footer contained in the inquiry report that the inquiry report itself ran to 67 pages. 51 or 67, it is written like that. Yet all these pages were not handed over to the applicant for some unknown reason. In fact, the enclosure in the inquiry report entitled Brief Statement of Case of Disciplinary Authority was not handed over to the applicant, as evident by the very same fact, although the enclosures were treated in law as part of the document itself. In total, the inquiry report and enclosure, if added, it would come to 67 plus 33 equal to 100 pages, but only 51 pages of the inquiry report was handed over to the applicant, your lordship. Now, they have replied, your lordship, at page number 89, your lordship.
Yeah.
88 or 89, your lordship.
Yes.
89, your lordship, will see first para itself. The sentence brief statement of case of disciplinary authority mentioned as enclosure by the inquiry report may have written by inquiry authority inadvertently. May. This is their record. They are supposed to be in possession of the records, your lordship. May have written the inquiry authority inadvertently as the brief statement of case of disciplinary authority contains 30 pages, and the same has not been received by the respondents along with the inquiry report, your lordship. So, your lordship, even they are not certain what the documents are in this case, your lordship. This point I wanted to highlight because ultimately the entire report has to be given to me, your lordship. Although this is not mentioned, reflected in the order, your lordship, but I have mentioned it in the OA. They've also replied, your lordship, into this, your lordship. And as far as that negligence part is concerned, your lordship.
Yes.
Even the UPSC in the advice has said that this was a bona fide mistake. Article 3, your lordship, that where the negligence concept has come in. That not negligence, your lordship, that miscommunication of the date, the 31/12/17, Article 3 of the charges, your lordship. That UPSC, even my learned senior is saying the same thing, that okay, this may have been a bona fide mistake. Even the UPSC has said that this was a bona fide mistake, your lordship, when giving the advice, your lordship. That's it, your lordship. I conclude, your lordship.
What is the?
Obliged, your lordship.
Item 6.
May it please the lordship. I love the appellant before your lordships. His appointment as a lecturer in Government Law College, Guwahati was assailed, my lord, by the respondent number 1. And the learned single judge was pleased to uphold the challenge. Now, one of the basic point is, my lord, the age relaxation which was given to the appellant, that would not have been given.
That was not given.
It was given, my lord. That is how it operates. I'll place
In
it.
fact,
A single judge, learned single.
APSC, this Public Service Commission was requested
Yes.
to grant this age relaxation, but it
In
was-
fact, my lord, the language is, I'll place the 2 OMs under which it was given. Before that, if your lordship would kindly come to that circular by which the relaxation was given, please come to page 103, my lord.
103. Yes, office memorandum.
Yes. Government have had under consideration for some time past the exercise of power by the competent authority under notification dated 3/5/51 in respect of relaxation of age limit for recruitment to the civil service or civil post in connection with the affairs of the state. The government, after due consideration, are pleased to lay down the following revised principle for guidance in dealing with cases for relaxation of age under the said notification. Please come to 3, my lord. In case of direct recruitment to the lowest cadre of a post through Public Service Commission, as per provisions of the service rule regulating recruitment to various services and posts, relaxation up to the age of 40 years may be granted in accordance with the procedure prescribed in subpara 4 below. Such relaxation may be allowed only case of those who are in services of the state government. This was the clause, my lord, which was, actually I was working in Accountant General's office. This clause was invoked, my lord. In case where the direct recruitment is not made through a PSC, the relaxation may be allowed to those also who are not in service of the state government. Now 4. Now this is what was invoked in this case. In case in which recruitment is made through Public Service Commission, the commission should be consulted before the rules are relaxed in the following manner. The appointing authority, when approached by a candidate for granting exemption, if it is satisfied that the case deserves consideration, shall refer the case to the Assam Public Service Commission to consider it on merit, notwithstanding the candidate exceeding the age limit, and commission shall then not reject the candidate merely on the ground of his being overage.
Shall not.
Yes. Shall then not reject the candidate merely on the ground of his being
That is the
overage.
provisional is at page.
My lord. The original copy is at page 106. On top, page 106. The appointing authority, when approached by a candidate for granting exemption, if it is satisfied that the case deserves consideration, shall refer the case to the Assam Public Service Commission to consider it on merits, notwithstanding the candidate exceeding the age limit and the commission shall then not reject the candidate merely on the ground.
There is mistake in your typing, there's type.
My lord will better read the original copy at page
Type
106.
copy, it is only.
No, my lord,
the
that's-
commission shall then reject the candidate.
My lord, that's why, I'm sorry, my lord, there's something wrong. Please read 106. I'm reading it again.
It shall not, then.
Shall then not reject the candidate merely on the ground of his being overage. The commission shall make his final recommendation having regard to the fact of the candidate being overage and will state whether in the opinion of this make the candidate unsuitable for the appointment in question. So therefore, in terms of this OM, my lord, the requirement is the administrative department will refer the case to the commission and commission will consider it.
Take a decision.
Decision.
Take a decision.
Yes, yes.
Can
Now,
you
my
give
lord,
me a-
I'll place the affidavit of the commission.
Make its final recommendation.
Yes. Now I'll place the affidavit of the commission, my lord. Now they say they have considered. Shall then not reject the candidate merely on the ground of his being overage. The commission shall make its final recommendation having regard to the fact of the candidate being overage and will state whether in his opinion this make the candidate unsuitable for the appointment in question. The fact that
State means they have to give their opinion stating
yes,
that is not fit for.
my lord, the language is slightly, I mean, it can be interpreted in either way. Fact of the matter is, my lord, the commission recommended my case and in the affidavit also filed before the learned single judge, my
What
lord.
is that recommendation?
Yes,
The commission recommended your case? Where is
yes,
that?
yes, yes, it is there, my lord. Commission's recommendation is at page 50. Page 50. This is from the chairperson to the secretary, higher education. Sir, 3 candidates were interviewed by the commission with the help of expert advisor deputed by the government. The following candidates are recommended for recruitment to the post of whole-time lecturer in BRM Government Law College, Guwahati, under Education Higher Department in order of merit. Serial number 1 is the appellant, Mila.
And where is the request letter of the state government?
Yes. My lord, government. Page 56. Here again, I will refer to page 57, my lord, the original one. In enclosing herewith a photocopy of the application dated 11/6/09, along with its enclosures, which is self-explanatory, I am directed to say that the government in the education department is pleased to refer the condonation of overage up to 45 years in respect of Asutosh Kundu for applying for the post as in terms of the government existing rule. Well, this is the format which government is following because the expression refer is used in the OM. And this is how they are operating, my lord. And in the affidavit filed both by the state government, my lord, the fact of the matter is.
There is in fact, the APSC has not taken any such decision and straight way passed this order of 19th of November, straight way sent this recommendation.
Yes.
Of 19th November 2009.
Yes.
And
Meaning
the
thereby,
single judge has ruled that since the APSC has not given any relaxation at any point of time.
So, my lord, if APSC has not given me relaxation, APSC would have rejected my case. the fact that APSC has recommended my case, there is it's implied that it was done. Now, my lord, fact of the matter is the petitioner has retired from service.
Now,
Yes, the writ petitioner respondent who filed the writ petition, he was also selected in the same selection process. Ultimately, it would have boiled down to a seniority issue. Now I have already retired, my lord. So he will get all the benefit.
Mr.
Yes, my lord.
He's retired from the.
I have
My
retired.
lord, by taking benefit of the stay, my lord. By taking the benefit of the stay.
Whatever it may be, the stay was
But
there.
my lord, the thing
Why
is,
should not have been moved any application for vacation of stay?
my lord, whenever the matter was listed, only adjournments were sought, my lord. That is the thing. But it was listed, my lord. It was not heard on time. But be that as it may, my lord, though he has retired, my lord, yet there is a decree from the civil court also. Decree from the civil court where his appointment was challenged by another lecturer, my lord. And there his appointment has been cancelled. The learned single judge has also made the same observation.
The civil court has made.
Yes. So even though he has retired, whatever action the government will take, it is upon the government. But his appointment was illegal, my lord. That
Now,
is the
what
question which
action-
is,
Now, what action the government is supposed to take?
maybe, my lord, he will not be entitled to the retirement benefits, my lord.
Certainly retirement benefits in the university,
My lord, there is,
Government law, my lord.
government law.
my lord, there is such. But that is for the government to take, my lord. Here, my lord, the question is whether his appointment was legal or illegal. My lord.
He retired when?
I think in January, my lord. In any case, my lord, if he wins, he will get seniority over me. Now, in any case, my lord, there is nobody to disturb his seniority.
Seniority is altogether different thing, but.
My lord, here only point is regarding relaxation. Now, my lord, the language of the circular is such, guideline is such. My lord, that is how the government understood. While government referring the matter, use the expression refer. And in the affidavit filed by the state government as well as, my lord, commission, they have taken the clear stand. We have brought on record, my lord. If your lordships will kindly come to the affidavit filed by the state government at page 110. Page 111, my lord.
Just.
Page 111, para 8. That with regard to the statement made in para 8, 9, and 10 of the writ petition, this deponent begs to state that relaxation of overage of respondent number 7, that is the appellant, was considered as per the existing guidelines of Personnel B Department. On the other hand, prayer for condonation of overage of Dr. Hiren Chandra Nath was rejected because it was not covered under the guideline issued by the Personnel B Department. Then as far as commission is concerned, my lord, the affidavit is at page 112 and the operative portion is at 114, my lord. One 115 rather, para 10. Is one, and that with regard to the statement made in para 8 of the writ petition, it is replied that the allegations are denied as per the terms of the advertisement, requirement in the matter of age of candidate was to be calculated as on 1/1/2009. Accordingly, on 1st of January 2009, respondent number 7 was found to be 44 years and 11 months. Although the respondent number 7 was thus overage, it was condoned by the government by letter dated 4709.
Not only this, even though if we come to the conclusion that yes, the APSC,
Yes.
not by giving any specific or issuing any letter, has granted the age relaxation. The question is the learned single judge is that this person was not entitled for age relaxation. He was a clerk. It was appointed.
No, my lord.
How
No,
to overcome with
there,
that,
with
sir?
all respect, the learned single judge was wrong. Because please come to the advertisement, what is the requirement?
Yeah.
One can be a clerk, my lord, so what? He's still a person and who is an eligible candidate.
Sir.
Please come to the advertisement, my lord.
Sir,
No, please come to the advertisement at page 42.
in the age relaxation is required to be given in very exceptional
No,
circumstances,
My
sir.
lord, there I agree,
What
my
are
lord.
those exceptional
Please.
circumstances? Yes, even though he's a clerk, but highly qualified or.
Yes, please come to page 42. What was the requirement?
42.
As per the advertisement. Kindly see, my lord, page 42.
Yes.
LLM with 55% marks with net slate or PhD. However, 5% marks in LLM is relaxable in respect of so and so. So all that was required was LLM with 55% marks with net slate or PhD.
He was having this.
I'm a PhD, my lord. So therefore, to say I was a clerk, yes, I was a clerk in the office of the AG. No teaching experience was prescribed in the advertisement. So, my lord, therefore, those may not be very relevant. Now, I would respectfully submit, my lord, this 103, if we read again, what follows is, my lord, what is the requirement is the government will refer the case. Kindly see, my lord. At page 106 again. The appointing authority, when approached by a candidate for granting exemption, if it is satisfied that the case deserves consideration, shall refer the case to the Assam Public Service Commission to consider it on own merit, notwithstanding the candidate exceeding the age limit. Let us stop, my lord. The requirement is whenever a candidate applies, then his case would be referred by the administrative department to the Assam Public Service Commission to consider on merit. Then what the commission will do? And commission shall then not reject the candidate merely on the ground of his being overage. Then the commission will, my lord, in my humble understanding, will not reject the case merely because he is overage. The commission shall make its final recommendation having regard to the fact that candidate being overage and will state whether in its opinion this makes the candidate unsuitable for the appointment in question. So only when the unsuitability is, my lord, found, it is in that case the commission will give its views. Otherwise, the fact that the commission considered its case, my lord, the assumption would be that his case was referred by the government and commission having found him suitable recommended his case. So in this, background, I'll respectfully submit, my lord, the observation of the learned single judge are not correct. My lord, to paraphrase my argument, my lord,
This, where is the admission by the APSC that they have given the relaxation?
yes. Page number 115, my lord.
115.
Yes. Para 10.
Yeah.
That with regard to the statement made in para 8 of the writ petition, it is replied that the allegations are denied. As per the terms of the advertisement, the requirement in matter of age of the candidate was to be calculated as on 1/1/2009. Accordingly, on 1st January 2009, respondent number 7 was found to be 44 years, 11 months. Although respondent number 7 was thus overaged by 6 years, 11 months, it was condoned by the government by the order dated 4709.
47/2009 is condoned by the government.
No, my lord. Let
From
me,
the application they have forwarded
my
to
lord,
the APSC.
let me come to this point again, my lord. Let me, subject to our lordship's consideration. My lord, the page 106, I have read it already, my lord. There is the requirement is whenever an application is made by any government servant seeking relaxation is raised, he will apply to the department. Then department will refer the matter to the APSC. The fact that the department refers the matter, now the matter is left to the wisdom of the APSC to judge its suitability. If it is unsuitable otherwise, if it is suitable, then his case can be considered. Well, that's my humble understanding.
Understanding, but here the APSC is saying that the state government has condoned.
My lord, because state government has not rejected, state government has forwarded his case.
The state government is only a forwarding authority which can forward any such application, and ultimately decision is to be taken by the APSC.
My
The
lord,
APSC,
my lord,
their
we-
affidavit has not
my lord-
admitted that we have condoned.
My lord, where is the requirement that government should condone DS? There is no requirement. Please come to 106 once again.
Yes. There is no.
The
question of-
appointing authority,
Ah,
when approached by a candidate for granting exemption, if it is satisfied that the case deserves consideration, shall refer the case to the Assam Public Commission to consider it on merit. So, my lord, the requirement envisaged by the notification is whenever there is an application, the state government, if it considers, then it will refer the matter to the APSC.
And the decision
I'm
of the
coming, my lord.
APSC would be fine.
Yes, yes. Now kindly see, and commission shall then not reject the candidate merely on the ground of his being overaged.
That's all.
So the circular also says merely because he is overaged, his or her case will not be rejected on that ground. Now, what is the duty of the commission? Commission shall make its final recommendation having regard to the fact of the candidate being overaged and will state whether, in its opinion, this make the candidate unsuitable for the appointment in question. If the commission finds the candidate to be unsuitable, in which case, my lord, they will state reasons.
No, even there is no question of rejecting his candidature or her candidature on the ground of overage.
Yes,
This part is over.
yes.
For any other reason, after granting this relaxation, if the commission found that he is unsuitable for appointment, then he has to give whatever it may be, unsuitable for appointment in question.
Yes.
Opinion, the commission has to express. His
Now, the
opinion.
fact that my
But-
case was recommended,
There must be an order.
No,
Yes.
my lord,
These
my humble understanding is subject to what your lordship will say. The requirement on the part of the government is to refer, and requirement on the part of the commission is to consider, despite his overaging. If he is found to be suitable, he will be recommended. If he is found to be unsuitable, despite he being overaged, he will be not considered. Sorry, he will be considered. And that is what flows from the literal language of the circular, Milord. I don't think, Milord, the literal meaning can differ in this regard. The commission shall make its recommendation having regard to the fact of the candidate being overaged. Even though he is overaged, commission will make its recommendation and will state whether in its opinion this make the candidate unsuitable for appointment in question. If he is unsuitable, question doesn't arise. If he is suitable, despite he being overaged, because government has referred the case, it will be considered, it will be recommended. That is the meaning which flows, Milord. Learned, single judge has given a meaning.
The commission shall make its final recommendation. Having regard to the fact that the candidate being overage.
Hmm.
And will state whether in its opinion.
Hmm.
This make the candidate unsuitable for appointment in question.
In other words,
Opinion, this, what is the meaning of this word?
my lord will
This,
kindly
and
give
this,
me, kindly give
this
me,
is incorporated here.
please read this para with page 56, my lord. That application which was forwarded by the state. Page 56, 57, sorry. Because the government understood it, their requirement is to refer. Please come to 57 for a moment. In enclosing herewith, a photostat copy of the application dated 11/6/09,
Just
57, my lord.
yes.
In enclosing herewith, a photostat copy of the application dated 11/6/09, along with his enclosures, which is self-explanatory, I am directed to say that government in the education higher department is pleased to refer the condonation of age up to 45 years in respect of Asutosh Kundu for applying for the post in terms of the government existing circular. Now the government is consciously using the word refer without saying that they have condoned it. Because the understanding of the government is the circular of 1980 does not envisage any condonation by the state government. What is envisaged is that the matter needs to be referred. And despite being overaged, the commission will consider the case. Now, following consideration, if commission finds the candidate to be suitable, then his case would be recommended. If the commission finds to be, despite the fact that he is overaged. But in case the commission finds the candidate to be unsuitable, then commission will state its reasons and reject his case. Itu suitable over unsuitable over. If your lordship has any lordships, my lord, can I make one submission, my lord?
Yeah.
If your lordship is having any doubt about this language of this circular, we can obtain another copy of this circular, my lord, whether those days the computer was not there, therefore the typings are normal type. This copy, whether if it is available in Gazette or in otherwise, we can try to get hold of a copy of this. If lordship is having any doubt about the, content of this.
It's confusing.
Yes.
It's confusing.
In fact, my lord, if this
the
expression
commission
is,
shall make.
no, that
the first
unsuitable
part
was,
says- The first part says.
yes.
They shall then not reject the candidate merely on the ground of being overage.
But to that extent is all right. That is also,
Here, so
so
the
far so good.
commission can't reject the
Merely
candidature
because
of a
overage.
person
Huh.
that your case is that you are not entitled as being overage.
Huh. They will consider on merit. Commission will consider on merit.
The commission shall take its final recommendation having regard to the fact of the candidate being overage and will state whether in its opinion, this make the candidate unsuitable for appointment in question.
Well, this word could be suitable or unsuitable also. I am also having some doubt. Miller.
It is in the opinion, whether in its opinion, the candidate is otherwise unsuitable for appointment should have been mentioned.
Could have been, could have been. Therefore, if a lordship is having any doubt, my lord, I can still try to have a better copy, better legible copy of this. ক'ব পাৰে, ক'বতো নোৱাৰা, ক'বতো কিবা ভুলো থাকিব পাৰে। তেতিয়া হেৰি আছিল না। Otherwise, my lord, meaning can be called out whether it is unsuitable or suitable. Sometimes, my lord, because of bad drafting, question of interpretation comes in.
If your lordship permits me to cover.
Yeah.
My lord, first of all, my lord, the OM dated 27/3/1980 at page number 103.
Yeah.
Is for state government employees.
Yeah.
He was not a state government employee.
So
He was a central government employee.
this case, the learned single judge is not
Has taken note of.
taken note
No
of,
finding on that.
non-suited, not non-suited this person that
On
he was
that
not
ground.
entitled for any relief.
If your
They have
lordship,
simply said
if your lordship puts, take page number 35.
35.
Yes, which is the part of the order. If I may read paragraph
Judgment.
number 10.
Yes, if we proceed,
If we proceed on the above ratio of the Supreme Court and take note of the ground of Ashutosh Kundu, respondent number 7, relating it to the appointment of the lecturer in the law college, it becomes apparent that without any background in academic field, the respondent number 7 can hardly be categorized as an exceptional or deserving candidate. It is also not a situation where other suitable candidates were not available. As the petitioner himself and the respondent number 8 had also participated and got selected in the same process, the clerk's job in the office of the accountant general may not also qualify the respondent number 7 to earn the permissible relaxation intended, if your lordship would mark, for the state government employees as per the specification of the OM dated 27/3/1980. So first of all, he was not entitled to get the benefit under this OM. And even if his case was referred by the government to the APSC, the APSC ought to have taken a final decision stating, notwithstanding the fact that he's overage, for this reason, he's entitled for appointment or he's required to be appointed. That is what the learned single judge had asked the APSC, and even the respondent number 7, you produced that response. That response was from the APSC was not there in terms of the OM.
That's right. But here this memorandum says, so there is no question of rejecting the candidature of a candidate who is overage once it is referred by the state government.
My lord.
Because it says, refer the case to consider it on merits, not standing the candidate exceeding the age limit, and the commission shall then not reject the candidature merely on the ground of being overage. So this question is over.
Over.
Once a person is overage and the government refers it to the APSC or the commission is not required to go into all this, whether he is overage or not. And they are required to examine his candidature on merits only.
My lord.
So once the APSC has recommended
There is no
his name,
there is no recommendation, my lord.
recommended his name for appointment.
My lord, the
That
thing
is,
is,
that is
there are two parts to this, my lord. There are two parts to this, my lord.
Why?
First, my lord, whether the respondent number 1 was entitled to get the benefit of the OM, which was meant only for state government employees. He was not a state government
That is the
employee.
question.
Yes.
Mr. Chaudhary, to You have to answer this question. Whether
And
he
they-
is an employee of a state government.
Well, these are not absolute, my lord. These are all, my lord, end of the day, it is the, my lord, end of the day, the government has exercised to decide, invoke this clause in my favor. Now it is too late in the day, my lord, after I have retired to raise all these points.
And the affidavit of the APSC also, my lord, in clear terms, does not say anything that the final call was taken, merely relies on the letter forwarded by the government, my lord. Merely refers to the letter forwarded by the government, nothing else. That is the reason why in paragraph number 12 of the order, categorically the single judge, honorable single judge, has opined that it is merely a forwarding letter. It no way speaks about the final call taken by the APSC. That is my statement.
My lord, one sentence, my lord, page 103, last two line.
Yeah.
Why I'm saying this is not, my lord, mandatory, or there is a scope for reading it as directory. Last two sentence, in cases where direct recruitment is not made through APSC, relaxation may be allowed to those who are not in the service of the state.
Where is that?
Last two sentence, my
In
lord.
cases where
In where the direct is not to be made through APSC, the relaxation may be allowed to those who are not in the service of the state government. So this OM is applicable also in cases of employees who are not in the service of the state government. So therefore, my lord, to say, what I'm saying is, my lord, what I'm saying is, it cannot be construed to be mandatory in that sense of the term. There is a scope of, my lord, reading it down. And then deep level. In GP Singh's interpretation of statutory statutes, my lord, I remember one sentence on this. Whenever there is a bad draftsmanship, there is always a scope for interpretation.
That's right. That is there. Check that too.
This is again directed against the author of the Central Administrative Tribunal. The issue is casual labor in BSNL. Lordship had in fact heard a similar case yesterday also. Lordship would recollect that many of these cases were remanded back to the tribunal to consider on the basis of evidence. Now, in this matter, my lord, the impugned order is at page
106.
106. There is a typed copy also. 106 is the true copy, my lord. There's no discussion as such of the evidence, but the general comments about, my lord, as to the importance of casual labor and their necessity in the organization, etc., was discussed, and my lord, it was allowed in terms of that another way of the same nature was already allowed by the tribunal. And whereas the material on record, my lord, shows, if lordship comes to page 59, in fact, they were independently already assessed. There are four respondents here who were applicants. My lord, in respect of the fourth person, my lord, there is no record at all. The other three persons were all independently assessed from page 59. So none of them, my lord, though they were engaged, were found completing 240 days. Now, this finding as such was never challenged, my lord. It's 59, 60, 61, 62, and 60, up to 64, my lord. These are the engagement particulars as verified by the BSNL upon consultation of all records.
So this is page number 59 is
59.
in relation to one.
Mohan Chandra Kalita, the respondent number one.
Kalita. Yeah.
Respondent number one.
So here what you have, under the above circumstances, you could not satisfy the eligibility as laid down in the scheme for the conferment of the regularization. Your case could not be considered favorable. Please take notice that you have not been in engagement under the department since June 1998, and the department is bound to consider only the cases such eligible for conferment against such vacancies were. This is in accordance with the, this is what your, how you have rejected this.
My lord, the page 60 is the findings relating to engagement, my lord.
Details of findings of verification committee. Authority to engagement. So and so, so and so. Proof of payment of name members of verification committee labor has not completed 240 days in working.
My lord. That was the basic criteria in the scheme. That as on 1/8/1998, you have to be working and you have to be
Who is for the other side?
completing
Who is
240
for the other
days.
side?
My lord, the advocate who was, my lord, leading earlier, my lord, he has also been engaged by the VSNL as a counsel for VSNL. So probably he could not thereafter step. Mr. Sharma, as Siddharth Sharma had appeared on one occasion. But then on the last two occasions, my lord, there was nobody, no representation from their side. And this committee findings, my lord, in a similar case that traveled to the apex court, my lord, the apex court had said in Devakumar Rai's case that the committee findings, if unless and until it has been dislodged by any other credible evidence, he would stand.
Mr. Pathak, we have to hear the other matter.
My lord, that is the difficulty, my lord.
Other side.
Now, probably if nobody appears, we have to take steps
So
afresh,
at
my
least the
lord.
advocate who was appearing, at least he should have mentioned this, that since I am not appearing. Who was the advocate, Mrs. B. Devi,
C. Devi, Mr. S. Sharma was also.
G. Goswami and S. Sharma.
C. Goswami, my lord, he has been, my lord, also, my lord, engaged by BSNL as a BSNL counsel. So probably he cannot appear.
And Mr. S. Sharma,
S. Sharma, my lord, he had appeared on one occasion, but on the last two occasions, he was not there.
and B. Devi,
EDP also, we tried to contact the last time, my lord, but then, in fact, when it was called, my lord, even the learned court master was also, my lord, asked to contact. But then there was no response on that day. Therefore, it was, my lord, absorbed. Otherwise, my lord, we have to take fresh steps otherwise, if nobody is appearing.
pass it over from him. Have you informed this Madam Chair Devi and Mr. Sharma?
On the last occasion, we had informed, my lord. But
Yeah.
then today, my lord, I could not contact. My
And
lord, I will
Mrs.
try again today, my lord. If
Yes.
we posted next week, then my lord, in the meantime, I can try.
Then we'll take another further steps if he is not, nobody is appealing
My lord.
without hearing, but much.
Deeply obliged.
Item 10, May I please, my lord. This petition against the order passed by the Honorable Learned Tribunal kept. What happened in this case? All the petitioner is now above 55 years, 58 years, my lord.
55 years.
No, 50 to 55 years. The only gist of the case is that they are working since 19 years, that record is also there. And in last occasion, Lordship has directed to produce the record. My learned friend probably, she says that there is no record of the case regarding engagement. My lord, page 18, first, 35 Ashok Kumar Das, they are working. Still they are working in the Brahmoto board, but on a contract. The Brahmoto board has given a contract to engage those persons, and they are engaged. They are in them. In this stage, my lord, let them to be continued with a fixed pay, my lord. If this process of regulation or any other thing will not help them also, my lord. They may not be terminated with a fixed pay if, because they are still now they are serving. Page 18, Lordship. The Yeah, poor people, when I am employed people, and main tax of this engagement, I have purpose of engagement. This has been described at page 5 of the petition. Still they are working. This is a Lordship will probably very much awarded. This is a platform area, entire Assam with any zone, not zone, not some zone. These poor people, 4-5 people, if they terminate it, they will not serve any purpose of government of India, I think. It's a very vast organized board. They have given their life in doing casual relevant work.
Now, what relief you are seeking, since you are not meeting the criteria of the government order, government of India order dated 10/9/2020.
I fulfill all the criteria. Lordship, kindly say, pay from 1983. I am working, Lordship. Kindly see the annexure. Page 18. Certified that C. Ashok Kumar Das and in event of village Topolia, Moza, Botola under Burberry Police Station.
Kindly come to the para number 11 of the impugned judgment of the CAT,
Pair number 11.
12 or 11. 11 can very well.
Record is this that they are working since April 2000. This is not the case, my lord.
They, as per the records made available, these applicants have engaged as
Yes,
so and so.
so and so,
It was
2001.
Seen from that, all the applicants are engaged from April 2000. Obviously, they do not fulfill the criteria stipulated in the ON number, and that must have completed so and so, so and so. The applicants cited case and other individuals granted deferral as follows. And then it would be seen from the date of about individuals hereby engaged since the obviously other cited individual fulfilled the condition as keeping in view of some. So this is what the finding that you are not meeting the criteria.
No. I mean, actually, this is wrong submission. Lordship, kindly see.
But
The record was called for. So record was called from them, whether I was engaged or not.
when record was called.
Earlier, this honorable court has directed to produce the record, my lord, whether they have been engaged or not. Into it. Executive has given certificate.
Lordship, this certificate has been found to be not original, Lordship.
No, not original.
Lordship, so cause notice, this junior engineer has issued the certificate, Lordship, and he has no authority to issue.
The executive now is also issued certificate,
Lordship, so he
not only
was
junior engineer.
issued show cause, Lordship, and in the show cause after inquiry, it was found that he has not actually issued any such certificate.
No. Then you should, criminal case should be lodged against the applicant where they got this certificate.
And this Lordship, petitioners were engaged on temporary basis, time to time, as per the requirement of work. They were
They
not the
cannot-
casual employees, Lordship.
They cannot, when they require, they
And as per
cannot
the
be thrown out.
requirement of the scheme, Lordship, on 1993, they have to be in service in
40
engagement,
days.
Lordship, for more, at least for 1 year. They were not in service, Lordship.
Record is necessary, why you are not produced the record?
And also
If-
earlier, as per the order of the Honorable Gate Lordship, the representation was disposed of by the Honorable, by this promoter board Lordship.
That was challenged before the
Rejected.
taking.
That was challenged before the, again challenged before the Gate, and Gate also upheld this rejection order. Against Lordship, they have approached this Honorable Court by this repetition. The only ground is that the executive assistant engineer has.
No, executive engineer.
There is no other ground, Lordship. That's
No,
why
engineer.
I see the grounds of this repetition. There is only one ground.
They are working continuously. This is my ground.
Trees.
Because similarly situated person
Base 12, Lordship, of this repetition,
has already been regularized.
not
and-
regular.
Regularized.
Yes, some were regular, Lordship. They were working since the 1989.
We are also working.
No,
And
Lordship, these petitioners are not working.
the certificate has been issued by executive engineer.
Base 12, only this ground, Lordship, that certificate
Time
was
to
issued
time.
by the junior engineer.
No, actually, you see the page number 20, 23 and 24. These are details by the executive engineer. And their casual worker, their certificate should be, their immediate superior officer is junior engineer. And in spite of that, executive engineer, the authority, executive engineer issued the certificate.
There is no record that they were continuing till 1993, Lordship.
Attendance register should be called for them.
These are
If they are getting money, how they could salary. There should be some receipt also.
They have not received salary, Lordship, only some 100 or 500 is. type of,
At that
uh,
time, 11,500 is there.
received.
At that 11,500 was there. Now it is casual workers doing, getting 12,000, 13,000.
Only one ground, Lordship, and this ground is also not sustainable.
Ground is that he is working for last so many years. It is the ground. Other grounds are not there. The scheme has been going and introduced by the government of India to regularize these casual laborers. So we are working and we should get the benefit. Till now, they are being engaged.
Since 2001, they were engaged, Lordship. From 2005, there is no engagement as Lordship temporary worker. All the workers were brought under the contractor, Lordship. Now they are working under contractor.
That is admitted fact.
And expert committee was constituted to examine the case of these casual workers for regularization. And as per this expert committee report also, Lordship, they have been working since 2001, April 2001, page 41. On the basis of record, Lordship, it is recorded. Page 41.
Which are those documents on which you are placing reliance?
I know the page 18,
18, read.
certificate say Usuk Kumar and in of village so and so, district of Nalbari has been delivering his service master labor since 1988 in different.
1988, which month?
My lord, that
Which
is
month?
the certificate issued on 24/9/1996.
88, which month?
Month has not been mentioned, my lord.
How can such certificate can be taken into consideration? And another.
Lordship, and another
Certificate page 20.
22, Lordship, kindly see that more month has.
Page 20, come to page 20 first.
Date of from his joining in the office of the Eastern Executive
For 1188, appointment is there. What happened thereafter?
Date 4/11/1988. Lordship, kindly see the next page.
Yeah.
Next original 4/11/88. The certificate is issued. It is a type copy and that,
4/11/88, that's right.
yes.
But up to which date you were working? Continuous from 88,
when?
where is that document, sir?
And Lordship, kindly see page 22.
Yeah,
15/5/90 gauze rain gauze station under Nalbari Investment Nalbari.
Lordship, may kindly see page 22, Ashok Das. Ashok Das, the serial number 3. He was shown in page 18, Lordship, as appointed in 1988. He is claiming that since then he has been continuing, Lordship. But as per this record, Lordship, Ashok Das was again engaged on 16/5/90. As per this certificate, Lordship, 16/5/90.
Time to time they bring engagement.
Yes. So there is no record of your continuation since 88 or 90. As per the requirement of work, some workers were engaged, but they have not continued.
Still now they are engaged, my lord. pro-contractor. Now they are at the verge of service retirement. Record is, they have not produced the record. Their payment register.
First of all, you have to satisfy the court that you are in continuous employment, then only we can ask the other party to produce the record. Nothing has been placed on record. You simply said 88 appointment, what happened thereafter?
Actually, my lord, this casual employee must have known, this engagement letter, they don't issue in general. In general, they don't issue the engagement letter. Only register book is available with them, and sometimes some officer issued some engagement letter to them. In general, the casual or master level, no engagement letter was issued. In general. Because it is not appointment letter.
For that purpose, you have to satisfy us that you're appointed on so and so date and your appointment was continuous.
I know
If that,
that record is not available with me.
that
My
record is
my
not
lord,
available, then what is the-
my lord, respondent authority has to certify that they,
Respondent authority has denied your claim by
denied,
filing an
but
affidavit.
but they have not produced the record, my
Sir,
lord.
where is the requirement of record? Once they
Record-
have denied,
I-
they have not filed any rejoinder to their denial.
But we have filed the rejoinder, my lord.
Sir, in the tribunal,
we-
they have not filed any rejoinder.
My lord, affidavit reply we have filed, my lord.
See here, the para number 5 of the judgment, the applicants have not filed a rejoinder to the written statement contradicting the contesting the details information given by the respondent authority in their written statement. You have not filed any rejoinder to the
Yes, on
written
the,
statement.
on earlier we have not filed the rejoinder.
Then what remains, sir?
And the record now in the lordship can direct it.
This writ petition is filed by the petitioners being reviewed with the order dated in first of December 2015, sorry. Agreed by the order dated 20th of March 2020. Passed by the Central Administrative Tribunal Guwahati bench. In OA number 137 of the 2016, whereby the OA filed by the appellants, by the petitioners, has been dismissed. Full stop. The petitioner, the petitioners has approached the CAT Guwahati in the year 2015, claiming that the petitioners were engaged by the from Brahmaputra board as casual laborers way back in the year 1990 and 1992. However, the Brahmaputra board has not taken any step to confer temporary status on the applicants and their subsequent, on the petitioners and their subsequent regularization as per the various points passed by the central government dated 10/9/1993 and 11/12/2006. The CAT Guwahati has disposed of the earlier OA number 325 of the 2013 referred by the petitioners wide order dated 1st of December 2015, directing the chairman Brahmaputra board to consider the case of the applicants judiciously after according opportunity of hearing to them regarding grant of temporary status and regularization to the petitioners. The Brahmaputra board wide speaking order dated March 17, 2016 has rejected the claim of the petitioners on the ground that the petitioners are not meeting the criteria fixed by the DONPTOM dated 10/9/1993, as they have not continuously worked as casual labor with the Brahmaputra board for 240 days. Stop. Being agreed with the said decision of the Brahmaputra board dated 17 March 2016, the petitioners have approached the CAT Guwahati again while OA number 137 of 2016, which came to be dismissed by the impugned order by the CAT Guwahati. The CAT Guwahati has recorded a specific finding that from the record available, it can be gathered that the applicants are engaged engaged from April 2001 and they do not fulfill the criteria as stipulated in OM number 10/9/1993 because they have not completed 1 year as on date, that is 240 or 206 days in a calendar year. Full stop. The CAT has also rebutted the argument raised on behalf of the learned counsel for the argument raised on behalf of the petitioners that similarly situated persons were granted temporary status by observing that all those individuals were engaged since December 1989 and they have fulfilled the conditions stipulated in the ON number 10/9/1993, and therefore the petitioners cannot claim parity with those individuals. After attempting to argue the matter for quite some time, learned counsel for the petitioner has failed to persuade us to take a different view as has been taken by the tribunal, and has also failed to produce any proof/evidence to satisfy the court that to satisfy us that the petitioners were engaged prior to April 2001, particularly from the year 1990 and 1992 as casual laborers by the Brahmaputra board. In such circumstances, we don't find any merit in this petition. The same is therefore this. Yes, sir.
Item 11.
My lord, in item number 11, we were served with a copy of the affidavit yesterday. We need some time to file our reply.
Copy of affidavit.
It was filed yesterday. The respondent filed their affidavit yesterday and it was served late in the afternoon. So we need some time to file a rejoinder.
Yeah.
After 3 weeks, my lord.
Adjourn.
Item 12.
May it please, Lordship. Here, I have challenged a particular rule of Assam College Employee Service Rule, Lordship. Page number 40, Lordship, kindly Lordship, see, Lordship,
40.
40.
Yeah.
May it, Lordship. Lordship, in all cases of appointment by direct recruitment as well by promotion, there shall be reservation for considered candidates belonging to the members of the SC/ST as per provision of the SC/ST Reservation of Vacancy in Service and Post Act 1917 and rule framed thereunder. There shall also be reservation for candidate belonging to OBC as per government institution. General order in respect of reservation in favor of the other categories of candidates like physically handicapped as may be in force shall also be followed. Since, Lordship, I have challenged this line, since an individual college is a separate entity for the purpose of cadres, reservation would be applicable college-wise for each individual cadre separately for which a proper register or roster shall be maintained. This is, Lordship. Why I have challenged, Lordship, is, Lordship, if Lordship goes to the page number, Lordship, 63, Lordship. This is a guideline, Lordship. This guideline, Lordship, it is guideline is issued by the University Grant Commission, Lordship.
Yes.
Lordship. This guideline, Lordship, page number 11, page number 65, Lordship. 8, 2, 3, 4. 4, 5, Lordship.
Rules of reservation.
Yes, procedure to be followed, the matters of reservation, Roman 5, Lordship.
Yeah.
The roster 14 point or 100 per point as the case may be shall be applicable the total number of posts in cadre only. As per our case, however, cadre is base indicated by seniority list governing the with the same by
scale, same pay scale, Lordship. What happened, Lordship? This clause 5 and 4 has been challenged before the Allahabad High Court, Lordship.
Yes.
Allahabad High Court. Allahabad High Court then found that, and in discussion in various Supreme Court judgment, Lordship, that yes, reservation should be cadre-wise, department-wise, Lordship. Lordship, find Lordship from page number 16 onwards. Several Supreme Court cases has been discussed, Lordship.
Yeah.
16, Lordship. Dr. Surendra Singh Verma says, in this case, the employment notice for the post of lecturers in defined subjects was issued by the Nagpur University.
They have quoted those judgments.
Let's
There is a finding.
Finding was, Lordship, that finding was that we therefore, Lordship, page number 49, that consider the
Page number
49.
49.
Yes, Lordship.
Yeah.
We therefore, by means of the judgment, wish to remand the request be UGC, which is statutory body constituted under the University Gun Commission Act 1956, to examine all aspects referred to in the above judgment of the apex court and submit its recommendation to the Ministry of Human Resource Development for its consideration and appropriate decision. Then, Lordship, UGC has submitted, Lordship. Lordship, kindly see page number 66, Lordship, in my petition, Lordship.
Yes.
Subject, implementation of reservation policy of Government of India. Sir, Madam, with reference to the above subject, I am to inform that implementation of reservation policy of the central government is and so 2005 directed the UGC to ensure effective implementation of the reservation policy in the central universities and those of institutions deemed to be university receiving aid from the public funds except in minority institutions under Article 31 of the Constitution. Accordingly, UGC violated so dated so circulated new guidelines for strict implementation of reservation policy of the government. This has been further reiterated by Ministry of Human Resource Development and so. The Ministry of Human Resource Development by its letter number dated so has directed the UGC to examine the issues mentioned in judgments as quoted by the Honorable High Court of Allahabad in so and submit its recommendation to MAHRD for their consideration and appropriate decision. Accordingly, UGC had constituted a committee and submitted in recommendation to Ministry of Human Resource Development on so. Thereafter, in compliance of the judgment of the Allahabad High Court, as upheld by the Honorable Supreme Court of India, and in view of the advice tendered by the DOPT and recommendation of the UGC MSARD, OM number so has intimated the department and so in accordance with the recommendation as under. Now, my concern is two, Lordship, clause 8 and 5. The roster, department-wise, shall be applied to the total number of posts in each of the categories, professor, assistant professor within the department subject. After Supreme Court judgment, Lordship, this has been issued, that it should be as department-wise, and Lordship. Then what happened? Review has been filed against the judgment, Lordship, Supreme Court judgment. It has been dismissed, Lordship. Then, Lordship, 2019, what happened? Then central government, an ordinance has been passed. That I am not going to the Supreme Court, then ordinance has been passed. Then Lordship will find the ordinance. Their affidavit, Lordship, page number. If this is not transaction, affidavit.
Lord, in our.
Yes, yes, Lordship.
Page,
Lordship,
page 32 to 35 in our affidavit, Lordship.
Page 32, Lordship.
Running page, Lordship, we have not.
101, Lordship. 101, Lordship.
32, yeah.
Lordship.
Lordship. Former Lordship, this is Central Educational Institution, Reservation in Teachers Cadre Ordinance 2019. And ordinance to provide for the reservation posts in appointments by direct recruitment of persons belonging to the scheduled caste, the scheduled type of the socially and educationally backward classes to teachers cadre in certain central education institutions established, maintained or aided by the central government, and for matters connected therewith or incidental thereto. This central education institution, I have no objection. To whom apply? Lordship, page number 33. This act will be applied to central educational institution, means Lordship C, page number 102, Lordship.
Page number?
102, running page 102 and 33 affidavit.
Yeah.
Yes. Central education institution means it will apply to Lordship. A university established or incorporated by or under a central act.
Yeah.
An institution of national importance established by an act of parliament. An institution declared as institution deemed to be university. Mainly it is for central university, Lordship.
Mainly?
For central university, central aided funds, etc. But I am not concerned in the central university. I am selling this Assam provincialized college service, Lordship. It was done as per the earlier guideline, Lordship. UGC guideline 2006, which was challenged and Supreme Court upheld that it should be department wise. I am a state university college, Lordship. I am not university. My challenge was to colleges, Lordship. So if this ordinance has been passed for central universities, Lordship, after Supreme Court judgment, my prayer is that, Lordship, now UGC guideline, that guideline 2008 is remain hold for the state colleges and universities. Central institution is gone, Lordship. Then my colleges, in my colleges in Assam state, aspect of clause number 12, it should be department wise. Why department wise, Lordship? In some colleges, some posts I have found that, Lordship, I have been specifically written in the petition also. 3 posts has been given to the OBC candidate, Lordship, by following 100 staff. I don't know how it has been given, but there are only 3 posts in a department. In Assam, only 4, 5, has 6, not more than 30. Then if he is given a four posts is there, he has been given to OBC by following 100 star, then it will be prejudice to the other candidate. But 13 star, it has been if followed department wise, then everybody will get, Lordship. That is my prayer, Lordship. So my prayer is that it should be department wise as per the apex code judgment, not for judicial, Lordship. Aspect from 1990, if Lordship go the Allahabad High Court judgment, there are several judgment changed. From the initial 1990, so apex code says that it should be department wise because their entry level is defined. And their promotion is also defined within a department. Head of the department is also from their seniority, not for other departments. But so it will help and it will be for the institution, Lordship. But colleges has not been following till now. So my challenge was that at least it should be department wise.
Should be amended in that.
Yes, Lordship. Only that para, Lordship. That is my number. By following it.
Wait, please, your Lordship. That Lordship, rule reservation rule 12, Lordship. May please, your Lordship. The reservation rules in the Lordship, it was formulated as per the Lordship, the apex court judgment, RK Sabal case, the 5 judges constitution bench judgment, Lordship. That was also UGC's regulation 2006, Lordship. That was put to silence before the Honorable Allahabad High Court, Lordship. And Allahabad High Court says that it should be a department wise, Lordship. Then it go to the Honorable Supreme Court. It upheld the Allahabad High Court judgment. Then Lordship, central government come up with an ordinance in 2019 The ordinance is as per the section 20 of the UGC's Act, Lordship. And that ordinance was came into Act, Lordship, after 6 months, Lordship. It is a, in our affidavit, we have annexed the Act also, Lordship. Yes. It is in Lordship, page 30. Page 36, internal page 36, Lordship. Page 36 to 38, Lordship. Yes, it is in page numbers, Lordship 105, Lordship. Running page, Lordship.
Short title and commencement.
Lordship. And this act was, Lordship, came into force, Lordship, all over India. On the basis of that, Lordship, my Lord may kindly turn the page, then Annexure 7, it page, internal page 39, Lordship.
Yes.
It says that the registrars of all central universities, all state universities receiving grants in it and deemed to be university receiving grants in it from UGC and government Lordship. Here it says that, Lordship, the Ministry of Human Resource Development, white letter dated so and so, Lordship, further the Central Education Institution Reservation of Teachers Ordinance Act 2019, Lordship, a copy of the notification of so and so annexed enclosed herewith, and universities are requested to start the recruitment immediately, Lordship. That was, Lordship, the ordinance says that, Lordship, the institute should be treated as a whole, Lordship. And it was a direction given by the regulating authority UGC, Lordship, to the all state universities also, Lordship. They have to follow the ordinance, which was, Lordship, by the central government, Lordship. It should be treated as a unit one, Lordship. Then, Lordship, next page also, Lordship, it is reiterated, Lordship. Internal page 40, Lordship, and running page 109, Lordship.
Yeah.
In continuation of this, it is addressed to the register of all universities, including the state universities, Lordship. In continuation to the office letter dated so and so, Lordship, it is clarified that for the purposes of reservation of the post in direct recruitment of teachers, cadres, universities, colleges, and institutions shall be regarded as a one unit, Lordship. It's a clarification given by the regulating authority, Lordship. Then, Lordship, next page, Lordship. Next page also letter issued by the UGC, Lordship, for implementation of the reservation policy, Lordship. If Lordship permit, I can read it, Lordship.
Yes.
Lordship. As you are, it's addressed to the all universities, Lordship. All you are aware that University Grants Commission is continuously monitoring the progress of implementation of reservation policy for SC, ST, OBC, and EWS, and persons with disabilities in teaching and non-teaching posts, as well as admission to all level of courses in the university and colleges. According to UGC Act 1956, the UGC has to ensure effective implementation of the reservation policy in universities and institutions receiving aid from the public funds, except of minority institutions under Article 31 of the Constitution. All centrally funded universities, college institutions are required to ensure strict compliance on the Government of India orders, rules, or on the reservation orders and rules on the reservation of their institute. Then my lord may kindly mark it. State universities, including its affiliated constituent college and other institutions functioning within the state, should follow the percentage of reservation for SC, ST, OBC as prescribed by the concerned state government. This is the direction of the regulating authority, Lordship. Then, my lord, next page also, Lordship. Page 42, Lordship, and running page is, Lordship, 111, Lordship. Yes. In second paragraph, Lordship, that is reiterated, Lordship. According to the UGC Act 1956, UGC has to ensure effective implementation of the reservation policy in universities and institutions receiving aid from the public funds, except in minority institutions under Article 31 of the Constitution. All centrally funded universities and colleges institutions are required to ensure strict compliance with the Government of India orders and rules on the reservation in the institution. State universities, including its affiliated constituent college and other institutions functioning within the state, should follow the percentage of reservation for SC, ST, OBC as prescribed by the concerned state government, Lordship.
Yes.
Then my lord may kindly come to our affidavit, lordship, page 19, lordship. Page 919, lordship, internal page. It should be, lordship, 88 running page, lordship.
Yes.
It's a office memorandum issued in November 2013, lordship. This is the presently holding, this office memorandum is presently holding in the field, lordship. It is a 100-point roster system, lordship. And then, lordship, page 90, lordship.
Page 90.
90, lordship.
Yes.
90, there is a backup table of 13-point roster. It is in respect of, lordship, non-teaching staffs, lordship. So, lordship, as per the UGC's, lordship, latest notifications and guideline, lordship, we have to follow the presently holding the OM, lordship. And it was as per the, lordship, prescription given by the UGC, lordship. And, lordship, the UGC's notification was issued under section 20 of the UGC Act, lordship. Lordship, it's section 20, lordship. Yes, chapter for miscellaneous, lordship.
Yeah.
Section 21, lordship. In discharge of its functions under this act, the commission shall be guided by such direction on question of policy relating to national purpose as may be given to it by the central government, lordship. Then, two, lordship, if any dispute arises between the central government and the commission as to whether a question is or is not a question of policy relating to national purpose, the decision of the central government shall be final, lordship. Here the central government decision was that, lordship, the institute should be treated as a one unit, lordship, not department, lordship. So the direction given by the central government on the basis of the ordinance, and then it was, lordship, as a act, lordship, that it should be treated as a one unit, lordship.
College should be treated as a one unit.
So college or university or institute, lordship, it should be treated as a one unit, lordship. And that was followed, lordship, by the state of Assam, lordship. And we are bound by the direction given by the statutory authority, lordship. We cannot go beyond that, lordship. The regulating authority is the UGC, lordship. And, lordship, regarding that particular issues, lordship, if lordship permit, I can rely the affidavit filed by us, lordship, to adjudicate, lordship. If lordship.
Yes.
And, lordship, I also pointed one thing, although I have not found the judgment, lordship, it is in the, lordship, the news portal, lordship, I received that particular 2009 Lordship, 19 Act clause also challenged before the Honorable Apex Court, Lordship, but Honorable 2019 that ordinance as well as Act, Lordship. That was put to challenge before the Honorable Apex Court, but that was not entertained by the Honorable Apex Court, Lordship. And it was negated, Lordship, Honorable Apex Court on the wisdom of the central government, Lordship. Although I am not got the judgment, Lordship. Then,
Yes.
if Lordship permit, I can read paragraph 6 onwards, Lordship. Then Lordship, it will be clear.
Paragraph 6 of
Speak
what?
so onwards of our affidavit, Lordship. It is in
Yes.
Lordship, internal page 73, Lordship. 73, Lordship, internal page.
Yeah.
So it's running page, Lordship. Paragraph 6, Lordship. That the deponent begs to state that Article 16 of the Constitution of India deals with equality of opportunity in matter of public employment. The relevant portion of Article 16 are set out below for ready reference, Lordship. 16.1. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. 16.4, Lordship. Nothing in this article shall prevent the state from making any provisions for the reservations for appointment or post in favor of any backward class of citizen which is, in the opinion of the state, is not adequately represented in the service under the state. Further, Article 46 of the Constitution deals with promotion of education and economic interest of scheduled caste, scheduled tribes, and other sections. The state shall promote the special care of educational and economic interest of the weaker section of the people, and in particular the scheduled caste and scheduled tribes, and shall protect them from social injustices and all form of exploitation. Then, Lordship, Article 385 of the Constitution deals with the claims of scheduled caste and scheduled tribes to service and post. The relevant portion is set out below for ready reference. The claims of the members of the scheduled caste and scheduled tribes shall be taken into consideration consistently with the maintenance of efficiency of administration in the making of appointments to services and post in connection with the affairs of the union and state. Then, Lordship, paragraph 7. That the deponent begs to state that Government of Assam Department of Welfare of Plain Types and Backward Classes issued a office memorandum under the subject representation of other backward classes and more other backward classes with the reserved categories in public service. This office memorandum was issued in consequence upon the amendments made in the Assam Scheduled Caste and Scheduled Types reservations in vacancies of services and Post Act 1978 and modification of earlier notification dated so and so by 100-point model roster is adopted for giving effect of reservation of vacancies for reserved categories including OBC, MOBC, with a direction that the roster register shall be maintained separately for each cadre in its establishment for giving effect to the roster register indicated in the office memorandum, Lordship. The guidelines shall come into force with immediate effect. All the appointing authorities under the state government will strictly follow the instruction, and any difficulties dispute arises should be promptly referred to the WPT and BC department. Accordingly, that already I have indicated that office memorandum, Lordship. Then 8th, Lordship, that the deponent begs to state that cadre of the purpose of roster shall mean a particular grade and shall comprise the numbers of posts to be filled by a particular mode of recruitment. In terms of the applicable recruitment rules, as per Section 3C of the Assam College Employees Provincialization Act 2005, the post in each provincialized college shall constitute an independent cadre for each category of employees except the post of principal of colleges. All principals of provincialized college shall be an independent and common cadre. Here, the assistant professor is treated to be a one cadre, and associate professor then go on is to be a one cadre. Then, 9. That the deponent begs to state that the Universities Grants Commission issued a guidelines on 25/8/2006 that the guidelines for strict implementation of the reservation policy of the government in universities deemed to be universities, college, and other grants unit institutions and centers. The relevant portion which were related to involved in the present petitions are set out below for ready reference. 6C. The practice of creating department-wise cadres which tends to create single post or cadre with artificially reduced number of posts in order to avoid reservation is strictly prohibited, Lordship. Then, Lordship, 7B. Without prejudice to the provisions contained in the clause A above, in all the educational institutions referred to in clause A above and functioning within any state shall follow the percentage of reservation prescribed by the respective state government, Lordship. Then 8A Roman 5, Lordship. The roster 40 point or 100 point as the case may be shall be applied to the total number of posts in cadre only in RK Saval versus so-and-so. Cadre is best indicated by the seniority list governing the members with the same pay scale, Lordship. Then, Lordship, 10. That the deponent begs to state that is, Lordship, challenge before the Honorable Allahabad High Court part, Lordship. Then, my Lord may kindly come to, Lordship, next page, Lordship. Running page 78, Lordship. After the Honorable Allahabad High Court judgment, Lordship, that was, Lordship, incorporated by UGC, Lordship. Clause 6C. In case of reservation for SC, ST, all the universities deemed to be universities, colleges, and other grants in institution and center shall prepare a roster system keeping the department and subject as a unit for all the levels of teachers as applicable. Clause 8A Roman 5. The roster department-wise shall be applied to the total number of posts in each of the categories: professors, associate professor, assistant professor within the department and subject, Lordship. Then, my Lord, may kindly come to paragraph 11, Lordship. That the deponent begs to state that before the amendment by the UGC, the practice of making department-wise roster was prohibited as it would lead to a denial of the reservation of smaller departments. According to the earlier clause 6C, Lordship, the practice of creating department-wise cadre which tends to create single post or cadre with artificially reduced number of posts in order to avoid reservation is strictly prohibited. Clause 8A Roman 5, Lordship. The roster 10 point and 100 point as the case may be shall be applied to the total number of posts in cadre only on the basis of the Honorable Apex Court judgment, Lordship. Cadre is best indicated by seniority list governing the members with the same pay scale. But in April 7, 2017, the Allahabad High Court granted a plea of challenging the advertisement. Lordship, that part is there. The amendment clause is there. Then, my Lord, may kindly come to paragraph 12, Lordship. That the deponent begs to state that under the earlier reservation roster, when the university college was taken as a unit, the SC, ST, OBC got reservation to some extent. But with the new roster, according to which the reservation will consider the department as a unit, there was to be a decline in the number of SC, ST, OBC as professors, assistant professors, etc. The roster shall be prepared taking university college as unit and do away with the department being taken as a unit so that get representation in academic work and teaching post in the spirit of our constitution, Lordship. To uphold the constitutional provisions for safeguarding the interest of SC, ST and socially and economic educationally backward classes, the Ministry of Law and Justice, Government of India was promulgated the Central Educational Institutions Reservation of Teachers Cadre Ordinance 2019 on 07/03/2019 to ensure preparation of roster by considering the institution as a unit The relevant portion is set out below for ready reference law. It's a 3-2 lordship. For the purposes of reservation for post as central education institution shall be regarded as a 1 unit lordship. Then lordship, that the deponent begs to state that the Central Educational Institution Reservation of Teachers Cadres Ordinance 2019 was subsequently replaced by the Central Education Institution Reservation of Teachers Act 2019, and same was notified on 09/07/2019 to ensure preparation of roster by considering the educational institution as a 1 unit. The relevant portion is set out below for ready reference. 3-2 lordship. For the purposes of reservation of post as central education institution shall be regarded as 1 unit. Then my lord may kindly come to paragraph 14 lordship. That the deponent begs to state that University Grants Commission issued letter so and so.
You are referring to this, yes.
Lordship. And that all the annexures which I am referring, that was lordship indicated here lordship. Then my lord may permit to read the paragraph 18 lordship.
Yeah.
Paragraph 18 lordship in running page 83 lordship.
Yeah.
That the deponent begs to state that section 26 of the Universities Grant Commission Act 1956 enables the commissions to make regulation only if they are consistent with the UGC Act. This necessarily means that such a regulation must conform to the section 20 of the Act. Under section 20 of the Act, the central government is given the power to give direction on questions of policy relating to national purposes, which shall guide the commission in the discharge of its function under the Act. Section 20 of the Act is set out below for ready reference lordship. 21. In the discharge of its function under this Act, the commission shall be guided by such directions on question of policy relating to national purposes as may be given to it by the central government. If any dispute arises between the central government and the commission as to whether a question is or is not a question of policy relating to national purpose, the decision of the central government shall be final lordship. The deponent further begs to state that to uphold the constitutional provisions for safeguarding the interest of SCs, STs,
So you
and
mean to say that whatever the provision is there
lordship,
in the act, that is in consonance with the UGC guidelines and the UGC Act.
lordship.
Therefore,
Lordship.
that has to be prevailed and can't be said to be.
Lordship.
Yes.
And otherwise also the power of UGC was lordship already decided by Honorable Apex Court in P. Susila's case.
It's also not disputing that.
Lordship.
Lordship,
That was their loss.
Lordship
And
is,
even lordship, if lordship permit, I can rely the affidavit of UGC also lordship.
yes,
UGC affidavit.
UGC
yes,
affidavit.
I am also relying Lordship. Lordship, I am going to show Lordship. One paragraph.
UGC's lordship paragraph 8 onwards, I am relying, not I am expressing lordship. Paragraph 8 onwards lordship, that is their lordship.
15 is important Lordship. I am going to assign Lordship 15 Lordship. Right. Page number 133. UGC
In place it on day after tomorrow.
Lordship.
Thursday.
Lordship.
Continue with that.
Lordship.
Day after tomorrow.
Yeah.
Karena